Please be seated. We will now hear the contribution of the Honorable Member, Ms. Nima Flugues.
Thank you, Mr. Speaker. I now rise to add my contribution to this bill. I would like to start by responding to the honorable member that went before me, Honorable Datadin, who made mention of adequate and prompt payment, which I will address a bit later, and regularization in Mocha Arcadia. However, Mr. Speaker, I did not hear Mr. Datadin make mention that a letter was sent to the Minister of Housing back in 2020 and in 2023, and it says, correspondence sent to your office and request for meeting with NDC rep. This was sent by the chairman of Mocha Arcadia NDC. And I read the first paragraph that says, reference the letters that were sent by the Mocha Arcadia NDC to your office dated the 18th of November 2020 and the 18th of July 2021, caption, assistance to remove squatters from reserve and Mocha Arcadia flooding situation and clearing of land in Mocha Arcadia NDC respectively. There has been no response to the same from your office to date. The status quo remains the same, though several promises by Mr. Aaron to report same to you. In the closing paragraph, it says, moreover, I'm hereby writing on behalf of the newly elected council of Mocha Arcadia NDC as a means of encouraging dialogue, clarifying our NDC boundaries and responsibilities, and to working along with you and your agency for the benefit of the residents of our community and to improve relationships generally with your agency. Yet still, Mr. Datadin says he doesn't understand what is the objection about the regularization in Mocha Arcadia. I would like to know if the honorable member would like anyone to walk into his house or if his area of responsibility without any form of communication and conduct a business. That is something that should be noted. I also note, Mr. Speaker, in the Honorable Edgell's response, I like a statement that he made. A state must be accountable and responsible. I like that statement. A state must be accountable and responsible. In the Honorable AG's presentation, he made some important points, and I note carefully. He identified that the laws is a century old, and then he made a statement. By what logic should the state not possess land? All we're doing is giving the state power to possess. That's his words. It can be confirmed in the answer. I take note of those words, even as I peruse the proposed amendment. Mr. Speaker, the Honorable Mr. Kroll stood before this House and gave a flowery presentation on the works of his ministry when it comes to compensation, relocation, and all of that. He highlighted for the first time that the Caneview issue, they had engaged in 2008 with the process. They did a survey in 2009, and then they suddenly revisited in 2021 what was missing from that piece of information is that the residents of Caneview were told to put up their monies so that they will be called shortly to pay for the lands. That was not mentioned. That was not mentioned in his presentation. Secondly, he spoke glowingly about lands identified in the vicinity. And he identified the areas valuation of properties were done, relocation contracts, and all of that in December 2021. But what the Honorable Minister failed to report to this House is that the people of Caneview who are relocated to these areas, I am more than willing to take a walk with the Honorable Colin Crowell, to these areas so that we can identify all the incomplete homes where these persons are living. And that is supposed to be a successful story, according to him. Many of those homes are not completed. No fencing. Some of them, the plastering not done. The ceiling is not completed. The drainage is not completed. And those people are there living. But yet still, the honorable member stood in this House to say that is a success story of relocation. What happened to the new cost that these set families of Caneview have to face for paying transportation to have their children taken back to the village so that they can be cared for by their grandparents, aunts, or uncles? What about the efforts and the monies they have to find to take them to and from school? That is not considered in the relocation. That was not considered in the package that he gave, that was given to those families. Life has not been better for those people. Life continued to be hard for them because many of them have to be walking far distances if they can't afford to pay a taxi, or they cannot get a bus to go where they have to go so that they can take care of their families. That was not mentioned. What about the negotiation when the staff from CH&PA engaged the people at Caneview, and some of them were told to go at 9 o'clock in the night at the office to conduct business? I didn't know that was the hours of negotiation. These are the things that must be mentioned. No thought, no care, no consideration was given for the people of Caneview, who had an established culture, who earned from the land. You remove them to an area where they cannot earn anything from the land. They farmed the land. They had their cattle. All of that was well established in the Caneview area. Then the minister, who said that they follow all these procedures in communicating with the people, had one meeting at which I was present. One single meeting with the residents of Caneview, and promised at that meeting that there will be follow-up meetings to engage with the residents. All we saw happening, you pull out one, get the other one, try to get this one to move, try to get that one to move, and that's it. You did not take into consideration persons who have their investment, persons who earn from the land. Where was the land for Mark? Everybody should remember Mark Gordon. He had 17 pigs, big pigs. He had 79 piglets. He had his turkey, ducks, fowl, his crops on the land, and many others. Where was the land allocated for Mark to continue his living? These people were told to sell what they have and take what the government is giving to them. Is that fair? Is that the process of relocation we're talking about? Something got to be wrong. And then you want to tell people that the persons whose homes were destroyed, they don't want to accept the compensation. If I have spent years investing, earning for my family, providing for them on the land, and then a government is to come and tell me, I will relocate you because a road is supposed to pass there. I will relocate you because a road is supposed to pass there. But you're not giving me land where I can return to earn. You're not giving me land where I can return to enjoy. Look at LaShonda Ellis, single mother, working at Ministry of Home Affairs, that was fired from her job during the KNView issue because she stood up, because she was trying to get a Guyana map from the wall for her daughter who was crying for the map that the teacher made for her. She was handcuffed. She was placed behind a police vehicle and taken to Providence Station. And you're telling me that we're following the laws of Guyana? Are we really doing that? When it comes to relocation of residents, is this process actually fair? Is this process actually fair and equitable for all Guyanese? What about those people who are still sleeping on the floor from KNView? Christmas time is here. What about those children who does not have a home? They can't even put up a Christmas tree. They cannot even hang a single decoration because the government claimed that the road was passing there. That was the claim of the government. And these are things that we should not forget. We cannot forget it. We talk about the residents at Peters Hall. The bridge was not to go there. You're building a new bridge just less than a mile away from each other. The old bridge is a mile away, approximately. And you have displaced so many residents who have lived their entire lives in that area. And you're annoyed and upset when people try to stand up and speak out for their rights. Is that right? That cannot be fair. When we talk about relocation, people's lives should not be worse than before. People must be able to return to a living where they're comfortable, where they can feel at home, where they can find some sense of security in the place that they're being placed. Not that they have to be hustling and bustling and trying to make ends meet and try to come to reality with what is happening. Mr. Speaker, one of the residents in Peters Hall, he lived his life there with his family. It is difficult to note that a senior has to be removed. We know the attachment seniors have with their properties, especially if they've lived their life there. That man had every little thing in his yard. He had his little shallot, his pepper, his fruit trees, all these things he had. And he got up every single day in the morning to tend to his plants, to pick and to reap whatever is sown there. Now, he has to be removed. The government think they've done an excellent thing by taking the family to an area. One, the people now have to catch a bus. There isn't any neighbors around. They can't plant anything as yet in the yard. So you rent a house with AC. A senior who live all their life in an environment where they can enjoy the fresh air and expect that that individual will be so happy and comfortable. That is not what they're accustomed to. Then the said senior would leave the same fancy house that they provide and just go back and stand and watch his place where he used to live. He stands there and he watches. Who provides the psychosocial support that is needed when these people are relocated and have to readjust to a new living, to a new environment, and all of that? Who provides it? You will tell the man that he's wrong or he's stupid or something you would want to say. But again, Mr. Speaker, when people have attachment to the things that they have, they've lived for years, it will affect them. It has to be a process. And the people who are administering the change and having these people relocated ought to show grace and compassion for these people. That is what they know. What any one of the ministers want anybody to say that they want to do development and come and grade down their home, put them out the next day and all of that. No, man. We need to think about that. We need to think about that. So even as we are dealing with people, we are dealing with people. And you have to find ways and means of communicating, meeting the persons, and trying to assist them to be comfortable so that they can relocate. Where is that? Where can we find it? You're coming to take in the name of development, but you're not willing to help the people to enjoy the development because of the stress that you add to their lives from the unfair practices and injustices that are meted out to them. We need to think about that. The Honorable Colin Crowe liked to talk about his flowery works. You see this picture? Sorry, can't put it in colored. I hope the Parliament could provide coloring the next time. Mr. Speaker, this is Diamond at the back. When you drive through Grove and you turn into Caneville, there's a passageway to go down to the back. And you drive about 2 miles. In driving the 2 miles, you pass streets with lights, no houses. You pass bush along the sideways, you're going down, no houses. You come to another street, there are lights. Then you reach a section, it's completely dark. And when you go down past the dark, there are people living. The government placed them there. There are people living without light and water. Again, Mr. Speaker, I will be more than willing to go with the minister so that we can visit the area and let us see if I'm telling the truth or not, because I was there. There are people living there without lights and without water. On those very lands, they were relocated. What are we doing? Relocation? Why would you put light in a street where nobody's living and the area where people are living have no lights? We're talking about development. We are talking about development, Mr. Speaker. And so, I would like the minister who made the presentation earlier to make himself available for us to go and check, facts check what was presented before this Honorable House. Mr. Speaker, I bring this other issue before you again. Relocation in the name of development, Mr. Speaker. You see here? These are plantains, trees. And Mr. Speaker, you see this? And again, I'm sorry it's not colored. This is the Gas to Shore project, where you have, while the work is being done, a number of persons lost their farms. They were graded down for the project. What compensation was given to those people? What compensation did you give the people who had all the plantain suckers graded down, the sapodilla tree graded down, and all these things? What compensation did they actually receive? It is quite interesting that we sit in this house and we talk glowingly about relocation and development whilst we punish people unfairly. Quite interesting. Mr. Speaker, after witnessing what happened to the residents of Caneview and Peters Hall, it is not surprising to see this PPPC-led government coming to this house to make changes that will legitimize their bullyism, to continue with the marginalization of ordinary Guyanese. Because we then had the legislation change when the Great Down came in view. So now it come in. All the things that have been happening to people, we didn't have the change in the legislation. But suddenly, we see the need to make the change when the challenge came from the people at Peters Hall. But suddenly, we see the need for the change, the acquisition of lands for public purposes, Amendment Bill 2024. This land acquisition bill is deeply tied to issues of historical injustice, ethnic identity, and socio-political dynamics. It is not a simple matter of land acquisition, but a test of fairness, justice, and equality in governance. Everybody wants to see development, but development got to be fair. When you're approaching the people who are involved, there must be fairness. And that's why I identify. I like when Crowe said, Honorable Colin Crowe said, we've been transparent. We've been fair and compassionate. Where was this transparency? Where was this fairness? Where was this compassion? When you dealt with the people at Caneview, and when you deal with the people at Peters Hall, where exactly is it? Where's the compassion? Mr. Speaker, we have inherited a legacy of inequality. Historical injustice persists, where indentured servants hold clear land titles due to their indentureship agreements. In contrast to the African communities, we are still grappling with unresolved ancestral land claims that was being perpetuated through the systems of inequalities. Our ancestors lost their lives. Some of them worked tirelessly, many worked tirelessly to build infrastructure, dig the canals with their hands, the drains, pull the canes, and all these things they would have done. Their culture, their identity was taken from them. Mr. Speaker, the current approach symbolizes a dystopian reality. It is marked with suffering, injustice, and abhorrent practices. It deepens existing divides. So we come with an amendment. How do we help? What are we doing to assist all of this? We got this legislation, we got the laws, we got all these things. But what are we doing? We come in 2024 to make an amendment again. But there are so many issues that need to be addressed, so why don't we address them if we're amending? Why don't we address them if we're amending the laws? Why are we just being selective in deciding that adequate and prompt payment is enough? What is adequate for an individual who live over 50 years on their land? Toilet, grow their family, everything right there, as against someone who came to the same area and probably lived for a year. And yes, they might have a fancy house, but they have no crops, no livestock, nothing on the land. They just got a nice big fancy house. How do we consider that? What is adequate compensation? Is it just the building that we value? Is it just the building that we add the value to? That person would have lived 50 years there. That person would have been able to tell you, I fetch mud. I build this. I do that. I did that. As against someone who came and met a road because the persons there was able to work, develop, and make things possible so the place can become a community. What is adequate compensation? When you remove an individual from the support system that they have in their community. We got to be fair. We got to be fair. Nobody's against development, but we have to ensure that the process and the steps that we take brings equity and fairness. I heard the minister mention, we have moved this body from here, and we have moved that body from there and there was no problem and all of that. I would love to go and do a survey and take all these people the yard city remove and let us go through the process of what was being done. And we might be surprised at what we will find if we talk about equity and fairness. Mr. Speaker, human rights and displacement is an issue. Disposing people of their land without proper consultation. I one meeting and then I decided to publish something in newspaper and then I publish it in the newspaper. I send a message here, I send 2 staff, I stick 2 things on the gate, whether they home or not, and then I move it with a grader and grade them down. There's not proper consultation. Compensation should include not only the building. Our cultural consideration, you see the thing is, we only thinking about the compensation in the terms of finance, but also the psychosocial support given by the government would be a part of the package. The psychosocial support given by the government would be part of the package. So in the case of the elderly who returns just to watch, and you're there to provide that kind of support for them, it helps. So this is what we need to look at. Cultural consideration undermines basic human rights. People who are connected historically and spiritually to their lands should be considered. Any policy ignoring these facts violates people's identity and dignity. Mr. Speaker, employing 21st century legal and political tools to justify unjust actions mirrors the colonial tactics of displacement and marginalization. This disappropriation harms vulnerable population while eroding the trust in the government. It is the ordinary people that suffers. Why the bridge didn't go to Houston? Let them tell you, why didn't the bridge go to Houston? Why it had to go to displace so many people? Why did it have to go there? That's a government decision. All the study was there to explain why it was recommended that the bridge goes to Houston. It was not. The government made a decision to take it that side. And look at the number of persons who were displaced. Their lives are disrupted. They made a conscious decision to do that. It wasn't by accident. And if you stand and you look at the bridge and all that is happening, you will get the picture of what is it that they're doing. These are the things we must. They should explain to this nation how many businesses suddenly own the lands along the Heroes Highway. How suddenly all these businesses own all these lands that open up. We talk about national development. We put the highway, and from the time the highway push, you see all these businesses. So all of them take over the place. How come? That is because it is something pre-planned. So the question is which lands you are planning to attack? Who you are planning to give the lands? These are questions we have to ask based on the actions we see by the government. Where is the genuine effort and fairness in this? It's 2 words to say, 2 words. And I'm going to repeat the words that they're using. Adequate and prompt payment. That's all that is important. Nothing else is important. Mr. Speaker, we have to do better when it comes to development versus displacement. Because we talk about infrastructural development for economic progress. It cannot come at the cost of just displacing communities like how you bury Cane View. They bury Cane View and set the flowers growing at Cane View. So that nobody who come for years and ain't gonna remember Cane View, that it had an area named Cane View existing. But I'm quite sure every family that lived on Cane View, every child that born, they're gonna remember Cane View. So we have to be conscious of this. Fair compensation and resettlement. Development must serve the public good equitably. Equitably. That's how it must serve our people. Historically, we know about marginalization. Man, we're in the 2024, the 20th century. Why is it that we cannot come up with proper mechanism that will bring fairness and equity to all. Why? We should be able to do that. We must, Mr. Speaker, I recommend inclusive dialogue. You're making a decision. You're bringing an amendment here. And you have a decision that will affect the lives of people. And you don't see it necessary to have proper dialogue and engagement with these people. It is important that we have that. Citizen participation. When you talk about moving people, there's people, it's face, it's human face there. You must engage these people. We must consider the ancestral claims. Advocate properly these legal frameworks that people can be comfortable. Guyana is made up of 6 races, not 1. And so, whatever decisions are made, we must consider all of that as we go through. We must have respect for our people. We must have the necessary oversight mechanisms when it comes to relocation of our people. It must be properly planned and structured so that when you have to remove people, you can engage them properly. You know, Mr. Speaker, in closing, when the Ministry of Housing initially spoke about removing the people at Caneview, I was asked some question, about the cultural background and all these things about the area. But I recognize that those information wasn't important. It wasn't even used or considered. Because if it was used or considered, the actions taken by the government would not have been taken. So if we're engaging people, if we are going to engage people on relocation, doing what they have to do, we must be able to consider. I thank you.
Thank you very much, Honorable Member, Ms. Nima Flug Best. Now for the Honorable Member, Mr. Kamraj Ramchatan.
No, sir. Yeah, I'm okay at this location. Thank you very much, Mr. Speaker. Mr. Speaker, these amendments that were brought here by the Honorable Attorney General seeks to deal with matters that are far more important, in my view, than the acquisition of land, as it were. It has to do with what I call the collision course, and you would appreciate this, of utilitarians and libertarians. Meaning, human rights as against developmental projects. And when in 1966, and even before that, we had started the construction of that charter called the Constitution of Guyana, we had to put in there certain fundamental human rights, which are going to be justiciable, meaning you could carry them to court if there are violations, or you can work out agreements with the state of Guyana in relation to how far you could have, in a sense, allow the state to, in inverted commas, violate it. What we have here is more or less that collision course in a very concrete sense. Very concrete sense. And to that extent, then, we have to be cautious, because we must not willy-nilly embark on the changes of laws that affect the Constitution, or the Constitution being affected by laws, and by very neat bypasses and artifices and devices, because then we would be limiting that human rights that we called there shall be a right to property. The right to property clause, as far as I am aware, was more or less drafted identical to the United Nations Human Rights Convention on Political Rights, where it states, as Article 142.1 states it. And it has remained that way, more or less, for quite a while, with the amendment of 2003, which then give the words prompt and adequate constitutional, being part of our constitutional vocabulary. No property of any description shall be compulsory taken possession of, and no interest in right over property of any description shall be compulsory acquired, except by or under the authority of a written law, and where provision applying to that taking of possession or acquisition is made by a written law, requiring the prompt payment of adequate compensation. This occurred whilst I was a parliamentarian, and I think you too, Mr. Speaker, in 2003, by Constitutional Amendment 2023 of 2003. Yes. We put in the words prompt and adequate compensation there. Now, when we put in the words prompt and adequate compensation there, it necessarily meant that every law in relation to compulsory acquisition, it automatically went in there. So, okay, it's a nice thing that Mr. Anil Nandalal, Honorable Member, seeks now from 2003, or since when he became a parliamentary. He didn't see it necessary, but he sees it now, and he takes a lot of kudos for it, that are now putting it inside of this Compulsory Acquisition Act. And y'all should be proud of me, but I'm proud of him. Even if he didn't do this, I'd still be proud of him. And so, that is a good thing. Prompt and adequate in the Act now, because it's in the Constitution. And you can't read the Constitution without prompt and adequate compensation. But that being so, I then saw that in that same Section 7, what I regard as a very dangerous development, whereby he sought in the Act to insert the words, but without prejudice to the state's right to vacant possession of the land. Now, I have done a number of cases in the courts, right up to the very highest of levels, and I have argued that indeed this is a cherished and entrenched provision in which you cannot take away private people's lands or land that belong to citizens of Guyana, even when you're compulsorily acquiring, and take that away before there is any prompt payment or adequate compensation. What I see in this, there was a recent full court decision in which Chief Justice Roxanne George indicated that you have to, before you get possession. That is why Mr. Steve Surajbali, right now, you can't take away his land and get possession yet, because you have not done what is called compensation. It has not been prompt nor adequate. So, well, whatever law you got now, the trouble is, it isn't. You have at least to get that done first. Well, one of the cases, there are lots of cases. Yeah, and I'm telling you, making up story, don't bother with you. This is what we have. This is why we have to be very vigilant and alert to our constitutional rights, Your Honor. I will quote the Constitution. The Constitution says that you cannot take away my property unless prompt payment and adequate compensation is paid. Yes. So what does that mean? It means now that you could bring an action here, a provision here, and say, what? But without prejudice to the state's right to vacant possession of the land. Meaning that you now, when you arrange your 80%, you can go into the land and start building your road. Well, no matter what you do, you just keep what you got there, man. You're going to read it in reply. You're going to read it in reply. Mr. Speaker, I am stating clearly that what the Constitution says is that you can take possession or compulsory acquire when it is that you have gotten adequate and prompt compensation. I believe, and I honestly state this to this honorable House, that if there was no need for wanting to have a right to vacant possession of the land, and they believe that they got it right now, why are they bringing, by inserting that without prejudice to the state's right to vacant possession of the land, why are they bringing that now here? The state never had the right to possession until, of course, compensation was paid. And the whole point of it is that, yeah, well, please do. All right, well, whatever it is, you want to give us the reason why it is that you ask that section 2A of your amendment, 2AC, be brought here? 2AC, the Honorable Attorney General seeks to put in the Compulsory Acquisition Act. 2, Section 7, 1 of the Principal Act, that is your Section 2, your Clause 2 of this amendment that you seek to bring here. Section 2C. First of all, he says in Section 7, put in the word prompt, as if we didn't know that the word prompt is the characterization of our compensation. It is adequate, yes. And now he puts in C. Yeah. Of course, I am saying it's a good thing. Yes, yeah. Clap yourself. You love that. As if it was not in the Constitution. We had done it long before you ever came to the Parliament here in the Constitution in 2003. Good. Mr. Speaker, what it is that is happening now is they give the impression that we now will have the power as a state, that as soon as you make all these other laws about 80% and you can give the court an ex parte, whatever, they have a right to go into that land. That is control freakism. That is control freakism. You ain't paid the adequate and prompt compensation yet, but you want possession. Yeah, that is what they want. And that is why he has put in that there. Now, you can say that the colonial people never saw need to do that. But now, Mr. Anil Nandalal, honorable member as he is, who would like to clap himself, is saying that I got the power to do that and to take possession of the land, notwithstanding the completion of the arrangement for compensation. Mr. Speaker, I was there in 2003. I was with that side of the table, and then we proudly did what we were supposed to do. So it is important that we see this little device moving and be alert and vigilant to it as to what it is that he seeks to do. If you want to put that the right to possession of the state to have the land, then put it in the Constitution. Put it in the Constitution. If it's not there in the Constitution. Just like how they're saying the residency requirement must be required in the Constitution before we can go and talk about residency requirement. It ain't got nothing like stating that you got a right to the possession of the land prior to paying compensation. It states only that you must take my land after you pay me compensation. And in constitutional, adequate, and prompt right. And that is what it is. Oh, you will want to say, but it doesn't prohibit it. Well, what are the express provisions of it? Mr. Man, you want to tell me,
Honorable AG, allow the honorable member to make his presentation, please.
without that section, or clause, I will call it at this stage, it necessarily means that we are not in conformity with the Constitution. You're adding something in the law that is not in the Constitution. And that is what I am saying, because, you know, the collectivist attitude of these communists and communists, they feel that they could go and take away the people's land without paying the compensation. I agree a concept called eminent domain. I agree that we have it in our Constitution, but our Constitution said before you take possession of it, you must, well, whatever Barnum do, I fight Barnum too. So don't give me that ball. The trouble is, you love to bring back conveniently history. Well, I was there with you. You probably weren't there when I was there. But the trouble is, we were all there. We fought against it, and we said the Constitution is the supreme law. And no other law that is inconsistent with the Constitution could ever, this one here, I am saying. Yeah. Mr. Speaker, we have a situation where under the existing law, as Mr. Kroll indicated, and let us take Mr. Kroll's narrative as accurate, that what we did is that we went and we talked to the people. We went and we paid them $150,000 rentals at some apartment. We went and feed them. We went and do all the good things to them. That is true. You know why? Because of the Constitution indicate that you just can't go and dispossess the people like that. What this amendment seeks to do now is not for like what Kroll did, is to say without prejudice to the right of the state to take possession. And they can go on with it. And so they mightn't give you the $150,000 apartment building or any food and nothing. Because that is what it is all about here. And it is far more colonialist than in 1914. You tell me whether this is advancing human rights. In all the judicial colloquiums he had at Bangalore and even in Georgetown here and in a lot of other places, we now going to water down, dilute that human right called the right to property. That is what we're going to do. By stating that the state, and by this devious method, devious method, No, well, I want to emphasize it. Yeah, because it might very well come up in court. Yes, well, that's right. So all the other provisions of this amendment here ought to be unnecessary, because he then goes on to say at 24A, where any land is acquired under this act. You can't acquire any land and take possession of it until you pay the prompt and adequate. But by this devious means, he will want to say that the article must be read now. In what way? Yes, section 7.1 will state that the expiration of 1 month from the date and so on and so on, the land specified therein shall vest in the state, subject to the payment of the purchase money or of any compensation as hereinafter provided. That is where the full stop is. But he going to put it now, but without the state's right, without prejudice to the state's right to vacant possession of the land. This is serious, serious business. This is serious business. And that is why I say that the powerful state, just like in the accused versus the state in criminal matters. We give him a right to silence. We give him a right to this and a right to that and all the rights. It is because the state is regarded as powerful and the pivot or the axis is always in the state's favor. So that is how we then try to entrench rights for ordinary citizens. And the powerful state must also be told in no uncertain terms that it should not take advantage of the common citizen that got a piece of property somewhere. But what the PPP government is doing, the PPP government seeks now to go and take away and say from that day, we didn't work out compensation yet, but we could now go and take the land. And they start building the road for the land. And what are you going to do? What will the common citizen that is poor, has no money to pay lawyers and things like that do? They're going to say, all right, boss, and I've agreed to that sum of money. And you take advantage of them. That is what is the imbalance here that a lot of people don't appreciate. And it is very fundamental that we must not disinherit or disenfranchise property rights of property owners in this country in this manner. So all this talk about fairness and transparency and accountability will be a thing of the past. It will be a thing of the present and future under this legislation. Because, as you know, Mr. Speaker, after signing that oil agreement, it got a lot of money now. And they can do the infrastructural works, although for them it was a rotten contract. The most rotten contract they ever could think about. But now, they're using it, building there, building here, whatever, without any feasibilities. Without any arrangement to see whether it is going to hit hard against people's rights and ancestral rights and so on. No, we feel that the road must run like that. No feasibility, road must run like that. So, and this is the high-handedness of it now. You know what we're going to do? Because some people might, under this constitution, on this law as it exists now prior to today, we are now going to say that we got a right without prejudice to a right to possession of the land, even before compensation is paid. That's the deviousness I notice about it. That's the dangerousness about it. And that's what makes it very diabolic. Thank you very much, Mr. Speaker.
Thank you very much, Honorable Member. The Honorable Prime Minister. Honorable Prime Minister.
Mr. Speaker, fellow members of Parliament, it is with a deep sense of duty and purpose that I rise today to share thoughts in support of the Acquisition of Lands for Public Purposes Amendment Bill 2024. The amendments of this bill represent a vital legislative step, a cornerstone for national development, ensuring fairness, transparency, and efficiency in the acquisition of lands for public purposes. Mr. Speaker, one of the previous speakers talked about the land acquisition issues in Cane View and in Moko. And they misrepresented what took place there. First of all, if you're there living for 15 years, 55 years, and you don't have title to the land, you are a squatter. You're living illegally on the land. And they have been living illegally on the land. And a caring government did not move them off the land. A caring government offered compensation and worked with them for over 1 year. Over 1 year. And you know what? You know what? Go and visit the 20-odd Guyanese who are now living on land with titles for the land, living in homes that were constructed from the compensation that they got from the government. That is the part of the story you must speak. You know what? You know what? We as a people, especially African Guyanese people, when you're in leadership position, you must not mislead the masses. Do not mislead the masses. What you need to tell the South is that immediately after losing the election in 2020, after the PPP would have formed the government, a former minister and the former head of the Lands and Survey Department went into Moko and told those people not to move. That happened. That happened. Valuations were presented showing $592 million to the land when the land was collectively valued at $56 million. That happened. Shame. This is a government led by two young ministers in the housing sector who went in and met with every family, spent hours with their technical staff, noting everything that they own and putting a value to it, and work through the compensation, fair and adequate compensation. Mr. Speaker, our country position is one of ongoing transformative development. What we are seeing here today in the House is a case and a continuation of the disruptive political agenda of the opposition. This must stop. Our people demand and must have better leadership from our opposition. Go and check the records. African Guyanese are getting house lots in large numbers now under the PPPC government that they had under the coalition government from 2015 to 2020. More empowerment. We call it Dream Realized, but in addition to Dream Realized, is a case of empowerment. We have a record of the last PPPC, the last APNU government giving out when they knew that the writing was on the wall and they would have lost the election. They were giving out house lots. And you know what? They were giving out house lots without any development of the areas. No roads, no electricity, no drainage, no water, and yet the honorable member will come and tell us about people living at the back of Diamond. I ask that you present the title for the land for the people living at the back of Diamond. We have not given out any title for any land in any area that already has roads, water, electricity, and drainage. Go and check the record. That is the history of the PPP. Mr. Speaker, the Acquisition of Lands for Public Purposes Bill addresses all these challenges head-on. It ensures prompt and adequate compensation, introduces advance payment of up to 80% to provide immediate relief, and strengthens the verification process to protect legitimate ownership claims. Contrary to what the honorable member just said, the honorable member Ramjatan, we are compensating all legitimate owners of lands. The amendment to this bill, in particular, seeks to accelerate the delivery of essential public services with greater efficiency and accountability while ensuring that Guyana's development uplift all its people and respect their rights and heritage. Mr. Speaker, land acquisition is often seen as a technical administrative process, but its implications are far-reaching. This bill, therefore, is about striking a delicate balance between safeguarding the rights of our citizens and advancing the common good of our national development process through critical public projects. Mr. Speaker, this bill seeks to amend the acquisition of lands for public purposes, Chapter 6205, to address two essential objectives. One, to ensure prompt and adequate compensation for those whose lands are compulsory acquired. Secondly, to enable the state to take possession of such lands in a timely manner, facilitating the swift execution of public interest programs. Mr. Speaker, our government has always been clear in its vision. We have made a steadfast commitment to foster inclusive growth through the provision of adequate and efficient government services and the creation of suitable infrastructure that can be conducive to the progress we seek to achieve. However, Mr. Speaker, development cannot happen without land, and the acquisition process must be handled with justice and sensitivity. And we have a history of doing that. Mr. Speaker, allow me to highlight the key amendments and the benefits they provide to landowners and the state alike. This amendment introduced the word prompt before payment and adequate before compensation. What does this mean for landowners? These two critical words modify the specific circumstances under which landowners are compensated, ensuring that once their lands are acquired, they are compensated fairly and without delay. Our government is founded on fairness and a commitment to prosperity for all, and we will not tolerate unnecessary hardships on our people. Further, Mr. Speaker, it ensures the state's right to vacant possession of the land. This provision is essential to prevent delays in the start of public projects that improve lives and drive economic progress. Mr. Speaker, with this amendment, landowners are assured of their rights, while the government is equipped to fulfill its obligations of continually building our country. Mr. Speaker, the new Section 24A establishes a robust framework for advance payments of up to 80% of the estimated compensation. This is a revolutionary provision with several benefits. The first benefit is immediate relief. Mr. Speaker, landowners can now receive a substantial portion of their compensation upfront. For families, this could mean financial security during relocation or reinvestment. We believe in respecting the property rights of our citizens. We are ensuring that through advance payments, landowners are not left in limbo. They can receive a substantial portion of their due compensation immediately. Secondly, the advance will only be issued when proof of title is provided. This prevents fraudulent claims and ensures that rightful owners are compensated. A third important benefit is mortgage protection. For lands under mortgages, the advance payment will assure the creditor's interests, protecting the financial obligations tied to the property. Mr. Speaker, our government understands that the acquisition of land can cause anxiety, but this framework ensures relief, fairness, and trust for all stakeholders. Mr. Speaker, Since taking office, the PPPC administration has made record-breaking achievements with regards to development we have fostered for the people of our country. To ensure that the efficiency of such public development continues, we must ensure that the concerns and issues that may be contributing to delays are adequately addressed while considering the welfare of our people. Mr. Speaker, in the case of land acquisition, delays can arise for various reasons. In some cases, it is the lengthy process of verifying ownership, particularly where land has been passed down through generations without formal titles. In others, disputes arise over the adequacy of compensation or the valuation of the land. Other issues could arise, such as complex legal challenges and prolonged negotiations with multiple stakeholders, which could create further roadblocks. Mr. Speaker, there is also, of course, the matter of aligning with global standards. In progressive democracies worldwide, prompt and fair land acquisition processes are non-negotiable. For example, in Australia, the Land Acquisition Act of 1989 ensures that compensation is determined promptly based on market value, with legal safeguards to protect landowners' rights. In India, another example, the Right to Fair Compensation and Transparency Act mandates both timely compensation and rehabilitation for affected communities, balancing development needs with social justice. Similarly, in the United Kingdom, the compulsory purchase process is governed by clear legal frameworks that prioritize fairness, ensuring that landowners receive adequate compensation and have the right to challenge valuations through independent arbitration. Mr. Speaker, as with these and other international examples, this bill aligns Guyana with global best practices and demonstrates that our government, and by extension Guyana, is committed to justice, efficiency, and the rule of law. Mr. Speaker, the amendments proposed in this bill also have a positive impact on national development, as they are not abstract legal changes. They will have a direct and tangible impact on our country's development. Further, where it is in the construction of a new school, an expanded hospital, or a modern highway, this bill ensures that essential public projects proceed smoothly and efficiently. Above all, Mr. Speaker, the amendments to this legislation directly contribute to our overarching vision of driving economic growth for our people. It sets out the framework for national projects to begin efficiently. National projects create jobs, improve connectivity, and stimulate local economies. Mr. Speaker, this bill encourages an uninterrupted commencement of critical national projects that are dependent on land acquisition. Therefore, its successful enforcement unlocks the potential for greater prosperity for our people. Mr. Speaker, I know that when we speak of land acquisition, again, concerns are raised. The 80% cap, as opposed to 100% upfront payment, is a prudent safeguard. It protects public finances while ensuring landowners receive significant relief upfront. Final compensation will be adjusted to reflect accurate valuations. Regarding the state's right to possession, we would not place our citizens in a situation where they would be displaced. Our government is enabling development that serves the greater public good. There's also a stringent verification process as the bill introduces strict requirements for proof of title, ensuring that only rightful owners are compensated. Mr. Speaker, honorable members of the opposition side of the House, rest assured that within this legislation are the requisite safeguards to ensure that no citizen is left behind. Mr. Speaker, in conclusion, I wish to reaffirm that our government's agenda is not about taking advantage of the people. It is about advancing a shared vision for national progress while safeguarding the rights of every citizen. We are building a modern, forward-looking Guyana, one that is transparent, fair, and responsive to the concerns of its people. Mr. Speaker, the concerns raised above about land acquisition, particularly those surrounding fairness, ancestral heritage, and transparency, are not being ignored. This bill carefully addresses those worries by ensuring prompt and adequate compensation, introducing advance payments for immediate relief, and establishing clear processes to protect legitimate claims. It is important to recognize that this is not just a matter of domestic interest. It is one that international human rights and development organizations closely monitor. The principles of fairness, equity, and the protection of property rights are fundamental human rights standards. And our government is unwavering in its commitment to upholding them. This bill ensures that the fair and equitable treatment of our people is non-negotiable, while formally rejecting any notion of unnecessary displacement or marginalization. At the same time, Mr. Speaker, we must recognize that the interests of individual landowners must be balanced with the collective interests of society. I should read again. We must recognize that the interests of individual landowners must be balanced with the collective interests of society. The schools we need to build, the roads and bridges that connect our communities, the hospital that save lives, these are not abstract ideals. They are the foundation of a better, more equitable Guyana, and they require timely access to land to become a reality. Mr. Speaker, our government has a proven track record of delivering to the people of Guyana. From investments in healthcare and education to modernizing infrastructure, we have worked tirelessly to improve the lives of every citizen. As Guyana takes its rightful place on the global stage, we must adopt international standards that demonstrate our commitment to justice, efficiency, and accountability. This bill reflects those standards, showing that we are a nation ready to embrace progress while ensuring that the path to development remains open and accessible for all. I urge that we all consider not just what our government has done, but what we will continue to do, always with transparency and trust as our guiding principles. As we move forward together, may we do so in unity, recognizing that progress cannot wait, but it must be just. Mr. Speaker, our government remains committed to striking the right balance, preserving the dignity and heritage of our people while delivering the infrastructure that will carry this nation forward. I ask this Assembly and the citizens of Guyana to trust in our government's commitment to building a better future for all, a future where development uplifts us as a people, where concerns are heard and addressed, and where we stand united as a nation that values its rights, its heritage, and its boundless potential. Thank you, Mr. Speaker, and I ask the members to support the bill.
Thank you very much, Honorable Prime Minister. Honorable Member, Mr. Roysdale Ford.
Good evening, Mr. Speaker. Good evening, colleagues, members of this honorable and distinguished House. I want to commence my contribution to this debate, to this very important piece of legislation, by acknowledging the contributions made in the course of the debate this afternoon by the members on our side. I believe that in each and every single one of the debates and the presentations made, the citizens of this country can come to the conclusion that there's urgent need to review and enact a new piece of legislation governing the acquisition of public purposes legislation. It is remarkable that in the course of the presentation from members on the other side of the House, particularly those who would have been present at the meeting yesterday afternoon, that they fail to recognize that very early in the discussions, the principal position of us on this side of the House was that there was a complete need for a new piece of legislation, and that was the basis for the call for us to proceed to the Select Committee. It was only after the Attorney General, the Honorable Attorney General, indicated his position that there would be no need for a new piece of legislation, and it will be going to no Select Committee, that we proceeded to analyze the piece of legislation which is before us. My learned friend, Mr. Nandalal, the Honorable Attorney General, in his opening presentation indicated that he sent to me by way of email the response reflecting the proposed amendments. To date and to now and at this hour, I'm yet to receive that piece of email sent. So when we come to this House and we speak about trust and distrust, we must understand that the distrust exists legitimately on this side of the House in relation to the government. The distrust is legitimate when the current government, as the basis for all the legislative agenda, the financial agenda, is the promise made to the Guyanese people that you will renegotiate the oil contract. And up to now, you have not done so. So when you deal with questions of trust, it's not bilateral between the opposition and the government. It is that you have failed to discharge your obligations and your promises made to the Guyanese people. When, as the sitting government, in the face of a court order directing the president to engage in consultation for the appointment of a chancellor and chief justice, and you fail to do so, that is evidencing your distrust of the Guyanese people and your failure to comply with the constitutional obligations of this country. Mr. Speaker, in the course of this debate, Mr. Speaker, we are yet to understand, Mr. Speaker, the true rationale for the government and largely the Attorney General coming to this Honorable House with this proposed amendment. We are yet to really understand, and the Guyanese people are yet to understand, what is the true mischief and what are the factors and circumstances which would have triggered the need for this piece of legislation. And because this Honorable House, Mr. Speaker, is not but simply a legislative body, but it records for posterity the events that take place in our country. I wish to place on record the true facts and circumstances which would have initiated this perverse piece of legislation before the House. Mr. Speaker, the Attorney General initiated a number of proceedings seeking to obtain possession of a number of properties in the Peters Hall area to acquire them for the purpose of the construction of the bridge. And in every single application that was filed, the government, through the Attorney General, sought immediate possession of these properties prior to the court determining the question of compensation. Mr. Speaker, the court, through Justice Graham, in a decision which was subsequently upheld in the full court by the Honorable Chief Justice and Justice Corbin, rejected the proposition as a matter of constitutional law and statutory law that it was possible to obtain possession before the payment and determination of adequate compensation. Mr. Speaker, it is necessary that I refer to the decision, and I'll have it here before you ask whether I walked with the decision as a matter of record to lay it over with the Honorable House. And I'm reading the decision of Justice Graham at the material parts of the decision, which, as I said, was upheld by the appellate court. And this is at Justice Graham at paragraph 34, Mr. Speaker, and I know you're very interested in these things. This is what the Honorable Judge said. The Land Acquisition Act in Guyana codifies this principle by establishing essential compensation payments before vesting. Such expressions require that the value of the property be ascertained. The procedure for land acquisition must comply with legislative mandates, which clearly states that the possession by the state is subject to the payment of compensation. Article 142 of the Constitution protects citizens for compulsory acquisition unless authorized by law. Paragraph 35. In balancing the respondent's individual rights against the applicant's public interest duty, the Constitution allows for property acquisition, but mandates the protection of individuals through adequate compensation. The Act grants the state the authority to acquire private land, but Section 7 specifies that the state's acquisition of land must be with the payment of compensation. The provisions for assessing compensation are found in Sections 13 through 19 of the Act. It is clear that at the time of the institution of the instant action, there was no agreement between the parties on the quantum of compensation. It is also clear that the parties are still not agreed on compensation, and therefore the applicant's request for immediate possession is premature in accordance with the Constitution, since there is no evidence that the quantum to be paid as compensation was determined. Resolving such issues or disputes is not merely a legal obligation, but a matter of ensuring dignity and equity for those impacted. Accordingly, in the court's view, within the construct of the Guyanese Act, for compulsory acquisition of property, albeit the property is now vested in the state, immediate possession is not valid until full compensation is determined and becomes due. Where the parties object to the other party's proposal, then the steps prescribed by statute for acquisition is restricted until payment is determined. The court therefore holds that payment as set out in the Act must be understood in relation to when full compensation has been determined, whether by court order, assessment, or by agreement. If full compensation has been determined, it is only then when payment is ascertained and becomes payable that the issues of immediate possession arises. It cannot be inferred that the government has power when the legislative position is clear that the vesting of property is subject to compensation paid. unless and until it is determined or agreed between the parties, the legislative provisions would be violated. Mr. Speaker, the court concluded, just for completeness at this stage, the court concluded at paragraphs 48 and 49 that in summary, Section 7 of the Land Acquisition Act is structured to ensure that while the state has the authority to acquire land, such power is balanced by the necessity of compensation. The use of the subject to payment underscores that acquisition is subject to compensation, reflecting principles that prioritize fairness and clarity in statutory interpretation. The rights of the landowners are safeguarded through these stipulations, maintaining the integrity of property rights within the context of compulsory acquisition as guaranteed in Article 142 and 39 of the Constitution. Granting immediate possession without resolving compensation disputes between the parties undermines the constitutional protections afforded to landowners under Article 142 of the Constitution. It allows the taking of property without just compensation, violating both statutory and constitutional mandates. Resolving the dispute is not merely a legal obligation, but a matter of ensuring dignity and equity for the parties in dispute. Mr. Speaker, without seeking to amend Article 142 of the Constitution, the Honorable Attorney General has brought to this Parliament, this National Assembly, a bill which effectively seeks to confer the right of possession, as stated in C, the proposed amendment C. Mr. Speaker, the Attorney General told us, and he took us around the Caribbean, to Trinidad, Belize, Jamaica, and all those places. But what is significant, Mr. Speaker, is that in none of those countries, the law exists where payment of compensation must take place before the state obtains possession. So what the Attorney General would have done, Mr. Speaker, was to pluck the concept, two concepts. First, that the state can obtain a right of possession when it is inherently inconsistent with Article 142 of the Constitution, whilst at the same time inserting a provision to deal with advance payment. When you examine, Mr. Speaker, for example, Trinidad, where the learned Attorney General seemed to take some of this legislative provisions from, there's a right of possession in the state even prior to the payment of compensation, even sometimes prior to the payment to the vesting order being made. Those are completely radically different provisions. So when the adverse circumstances are brought into this act, Mr. Speaker, it creates what I consider a legislative mismatch of provisions. And you see it clearly, Mr. Speaker, in 24A of the very provision, which starts off in the first line, where any land is acquired under this act. Judicial authorities have declared, Mr. Speaker, that for the purposes of compulsory acquisition, it is not when simply the state is able to obtain a vesting order that the land is acquired, but the land is acquired upon the payment of full and adequate compensation. So inherently, Mr. Speaker, in the first four words in the first sentence lies an inherent conundrum and conflict which cannot be resolved, because when the land is acquired means that when the land is being taken and vested and full compensation paid, but nevertheless it proceeds to lay out a remarkable though incoherent legislative system and regime which makes it impossible for the advance payment to be legitimately made in the context of the Constitution and the legislation that exists. So, Mr. Speaker, we are in a peculiar circumstances. Mr. Speaker, the full court approved in this same judgment, and of course, this was a case argued by Dr. Todd Mrs. Smart, and led by myself against representatives of the Attorney General, the court dealt with specifically, Mr. Speaker, the concept and the underpinning principles in relation to this advance payment. Because as I pointed out earlier, Mr. Speaker, all the applications before the court sought to have a provision that the court makes an order that the monies be lodged pending proceedings. And you were told, Mr. Speaker, that yesterday in the court that a number of persons surrendered their properties. Mr. Speaker, I need to bring some clarity to that. Of the 5 or 6 cases that were heard yesterday, most of the persons agreed to accept by consent a payment paid to them, and because it is not completed, the court will proceed to hear the proceedings. That is a completely different situation, Mr. Speaker, where the parties consent to a particular situation. What we are having here, Mr. Speaker, is a legislative enforced position where the state is, by legislation, seeking to create the circumstances where the citizens must surrender their right to property as declared by the court and as set out and enshrined in the Constitution for 80%. When at the same time, 80% does not constitute full and adequate compensation as determined by the court. At paragraph 40 of the decision, Mr. Speaker, dealing with the question of lodging money pending determination of adequate compensation, the court, as approved and held and upheld in the full court, said the importance of lodging money pending compensation is highlighted by the applicant's offer to deposit compensation with the court, which landowners can choose to uplift. This sum represents the state's chief valuator's assessment, which the respondents dispute, arguing that allowing the parties to uplift this amount effectively compels them to accept it before compensation is finalized, indicating an attempt by the applicant to circumvent the statutory requirements in the face of the dispute on the adequacy of compensation, and this invites future litigations. This dispute regarding compensation is the crux of the applicant's substantive matter, the state, seeking immediate possession without affording the respondents, the citizens of this country, irrespective of race, class, creed, and where you live. This is a bill that will touch each and every one of us, from the Rupununi to Georgetown to Oriala to Essequibo Coast, in Linden, every part of this country, without affording them the requirement of a fair hearing on the disagreement on the adequacy of compensation required by law, undermines the established statutory process set out in sections 13 to 19 for determining compensation. The argument of an amount being an interim payment pending the determination of compensation would amount to a value assessed by the valuation officer and not an amount determined following assessment within the statutory framework established for assessing compensation. In the court's view, granting immediate possession on the basis of an interim amount not assessed and not fixed by the court, in keeping with the statutory framework, would undermine the Act and the constitutional protections under Article 142. When parties contest a proposed compensation amount and statutory acquisition steps remain incomplete, possession cannot be granted until all the legislative conditions are satisfied. The court therefore holds that the deposit of the value assessed by the valuation officer, or as in this provision here, by the minister, as an interim payment, does not satisfy the legislative requirement for the determination of adequacy of compensation permitting an immediate possession sought by the applicant. Mr. Speaker, the conundrum and the embarrassment that this government now faces because of this legislation, must lie at the foot of the Honorable Attorney General. As I said, it is a mismatch. The Trinidadian Constitution, the provision in Section 4 of their Constitution, is incomparable as it relates to Article 142 of our Constitution. It is because of the historical injustices which were taking place from the time of the Crown in relation to the assertions made against the PNC and the government, because of the assertions made against this side of the House now against the government in relation to land, in relation to the issues affecting land, the emotion that it triggers in this nation. That is why this House, by virtue of an amendment to Article 142, laid a foundation that cannot be circumvented, but that irreversibly ties and irreversibly ties and connects the question of the adequacy of compensation to the prompt payment. It could not be separated, Mr. Speaker. So to pluck a provision from a completely different constitutional architecture and environment and to place it into this system is improper. Mr. Speaker, to the extent that we want to have and to promote the government's agenda for development, and I want to make it clear so that we will have a clear understanding on this fundamental issue. We sit in this House as representatives of all the Guyanese people. And we support the development of this country. We support the development of the country. We support the development of infrastructural works, development for this country in the context, oh, shut up, in the context of the law and the Constitution. It is a fundamentally different position. It's a fundamentally different position when you seek to bring in place provisions which are not consistent. Mr. Speaker, it is amazing, Mr. Speaker, that the leading country in the Commonwealth, whose constitution and legislative system is the closest to us, mirrors the decisions made by the full court. In India, Mr. Speaker, Section 17 of even the old Acquisition Act of 1894 had a provision that stated clearly that before the taking of possession of the land, you must tender and pay at least 80%. And the Honorable Attorney General brings to this distinguished House, since 1894 in England, brings a piece of legislation which is inconsistent with the decisions made by this court a few months ago, little over a few months ago. Mr. Speaker, we're told that there's no need for any new bill, either directly they're saying so by inference of their rejection of the concept of taking this issue to a select committee. Mr. Speaker, the new legislation in India, which is 2013, passed by the Indian Parliament, did a number of important things, Mr. Speaker, which are not present in our law. And the references to Mukherjee and so on has all been repealed. The validity of those judgments have been set aside by the right to compensation and transparency in Land Acquisition, Rehabilitation, and Settlement Act of 2013. And in this act, Mr. Speaker, a few principles which are present in it are completely absent from our law. And Mr. Speaker, I am not standing up here today speaking as an opposition member of parliament only. I have had the opportunity to be a lawyer representing people who would have been suffering as a result of the compulsory acquisition process. And Mr. Speaker, the government needs to understand, that not every criticism of a system and a process is necessarily a criticism of them personally, and stop being so petty. Mr. Speaker, this new bill in India, Mr. Speaker, guarantees the right to fair compensation, rehabilitation, resettlement, and bringing transparency in land acquisitions, rehabilitation, and resettlement. They put in place, Mr. Speaker, a whole system to address a lot of the concerns that were raised by my colleagues. The whole concept of a social impact assessment and how that impacts on the life of the people whose property is going to be compulsory acquired. Mr. Speaker, we're told that this bill and this simple amendment guarantees transparency. I'm wondering if the Honorable Prime Minister could, I'll cede 5 minutes to him, if he could identify the clause in this bill that promotes transparency. Mr. Speaker, in the very course of the very proceedings, we have had to file court proceedings within these compulsory acquisition processes initiated by the Honorable Attorney General to obtain what does not exist by way of express provision or by the government's commitment and demonstration to transparency in relation to what is happening. Mr. Speaker, the PPP today, through the Honorable Minister of Public Works, the Honorable Minister of Labor, and the Honorable Prime Minister, not by pure accident, all of them being African Guyanese, stood up in this house today and berated the opposition and sought to caution African Guyanese from listening to the opposition. But Mr. Speaker, the cause of the persons in Peters Hall, Mr. Speaker, I have seen it personally. I've seen the crying, the tears, and the destruction to their lives. And we have made an application to the court, Mr. Speaker, on the 18th of September this year, which was heard promptly by Justice Kissoon. We went to court to obtain compensation agreements signed by the government and its agencies with persons who would have received compensation. The people are saying, Mr. Speaker, for race and other reasons, political and other reasons, the process has not been fair, and the allocation of property and compensation rights have not been fair and equitable. Mr. Speaker, the court entertained the application, Mr. Speaker, and granted certain orders. The court granted an order, Mr. Speaker, that on the basis that the state has invoked its powers under the Constitution and under the Public Purposes Act, and this is from the decision of Justice Kissoon, I could lay it over with the court, for the purpose of taking a single purpose, that is the construction of a Demerara Harbor Bridge, and in this context, some of the documents ought properly to have been provided at the time the request was made by senior counsel, referring to myself, because the question of relevance. The court went on to say, Mr. Speaker, it is in the context that relevance and the ability of the court to justly deal with the issue before it, that it must be examined in the context of the 50 properties that were or in the process of being acquired by the state within a single area. The court went on to say, Mr. Speaker, that the orders sought in the notice of application must be granted. Without a doubt, all of these documents relate specifically to the process of taking the assessment of compensation for the properties adjoining and pursuant. They have a direct bearing on what the court has to determine in relation to these issues. And the court, Mr. Speaker, made this order, I think, on the 20th, and fixed the hearing of these proceedings on the 30th of September. The state has refused, Mr. Speaker, to deliver those documents to the court. They have appealed to the full court, and that appeal is pending. And we're at the close of almost 3 months after. But nevertheless, the government comes with this sense of urgency, speaking about transparency in relation to the process for which they are themselves refusing to provide information as ordered by the court. Mr. Speaker, there is no doubt that this piece of legislation and the substantive act continue to perpetuate all the colonial features of oppression against the citizens. Mr. Speaker, I want to put on record a statement by a court for us to sit here today and for the purposes of prosperity, in the future, Mr. Speaker, prosperity. It says, Mr. Speaker, at paragraph 23 and 22 of a decision, and I'll call the name of the case Sadar Ulmulk against the government of Khyber, a decision of the Pakistani court. This is what it says, Mr. Speaker. A full-scale law of land acquisition for the whole of the British India was introduced in the year 1857, which was amended the following year in 1870, following the present law of 1894. According to the Gazette of India of 1892, the object of the law was to protect public funds. It means that this law did not aim at the determination of fair compensation. Fair and adequate compensation for land acquired by public purpose is also an important issue in international human rights law. It has assumed greater importance in the background of forced eviction for a range of public purposes. The Act of 1894, which is like the 1914 Act, Mr. Speaker, until it was repealed in its entirety in 2013 by India, is a relic of colonial law in the Indo-Pakistan continent. There has been self-evident public dissatisfaction with the determination of compensation by executive authorities concerned. It is high time we consider introducing a new law altogether so that the colonial tinge of the law could be transformed into a human rights approach through constitutional obligation of the executive authorities of the state.
Honorable MP Senior Counsel, your time has expired 3 minutes ago, so you will need an extension to continue.
Could I request?
Thank you very much, Mr. Speaker. May I ask for the honorable member to be given an extension in keeping with the standing orders? Thank you.
Thank you. Honorable member, you may continue.
Sorry, Mr. The same case, the judge continued at paragraph 24, that a human rights approach to land acquisition must be defined as recognition of land as property and peaceful enjoyment of its possession, a source of livelihood in terms of economic rights and a characteristic of identity linked with cultural and social rights. Mr. Speaker, in the decision of our court, I just want to say it, I would not read the part because of time. The court specifically stated that until full and adequate compensation is paid, the landowner has the right to possession, and has the right to enjoy possession. I just want to make it clear, Mr. Speaker. Mr. Speaker, it seems as if it is a source of derision and discomfort for honorable members of the House to have members of this side of the House speak on the issue of African ancestral lands and also to speak on the issue of land rights in relation to our indigenous people. Mr. Speaker, African ancestral land rights in Guyana lack the comprehensive legal protection afforded to indigenous lands. These lands included lands established by villages by freed Africans through collective purchases, which hold significant cultural, historical, and socio-economic value. Under the current legislation, as well as even these proposed amendments, they fail to adequately safeguard these lands from arbitrary acquisition and insufficient compensation. This creates inequities that perpetuate historical injustices and leave many of the Guyanese communities, particularly African and Amerindian communities, vulnerable to displacement and to the loss of cultural heritage. I call on this Honorable House, Mr. Speaker, for protections similar that exist in relation to the Amerindian Act to be enacted as a matter of law and as a matter of urgency to secure African ancestral lands so that they could be legally recognized as a distinct category of landholding, acknowledging their historical and cultural significance. I would have hoped to hear them on the other side standing up to support such principles. Free, prior, and informed consent, Mr. Speaker, must be part of our law in relation to all the people of the country. I call, Mr. Speaker, for us to establish a National Lands Commission to deal and protect with all lands in this country. Mr. Speaker, we are here today not because we want to come before this House and be incapable of saying and determining the difference between battalion and battalion, Mr. Speaker, because we want to understand that the Honorable Member Ramson could finally say battalion and not battalion. We want to focus, Mr. Speaker, on the need to have proper legislation to protect the land rights of our people, which this current bill and the substantive piece of legislation fails to do. Thank you very much, Mr. Speaker.
Thank you very much, Honorable Member, Mr. Roysdale Ford, Honorable Attorney General and Minister of Legal Affairs, Mohabir Anil Nandlal, Senior Counsel.
Thank you very much, Mr. Speaker. Let me begin from where the last member left off.
Honorable AG, just give me 1 minute
Yes, sir.
to interrupt you, so I don't have to interrupt you again before, and call on Parliamentary Affairs Minister to move that the standing order be suspended so we can proceed beyond 8 p.m. Gail, we have to move the motion because we're going to go beyond 8 p.m.
May it please you, sir, respectfully asking that the relevant parliamentary provision be suspended to allow us to go past 8 p.m. until the work of our
Conclusion.
business is done this evening,
Thank you
as
very much.
instructed by the Chief Whip
Thank
of
you,
the
Minister Manik Chan. Honorable AG.
Thank you,
may
sir.
continue.
Sir, so the issue of African ancestral lands has been a running theme through this debate. And we have heard all manner of allegations and contentions that this bill affects African ancestral lands. Well, Mr. Speaker, the bill is public and the law that it seeks to amend is also public, and anyone who is interested in this topic can go and read the bill and the substantive act, all 14 pages of the principal act. And if they can find anything, either expressly or by implication, makes reference to any ethnic group in this country, including African Guyanese, then I will resign from this parliament. Any person who can find any reference to any ethnic content in either the bill or the principal act, I will resign, sir. The second point I want to make, sir, is that every person on that side who chose to speak about African ancestral land has not left us at all with any definition of what this concept is. No one is yet to explain what this concept of African ancestral land is. My grandparents are from Monrepo, and they own 2 properties in Monrepo by transport. Grandmother, paternal and maternal. I suppose that would be, those 2 properties would be my Indian ancestral lands. I am just reasoning by way of parity. Not the entire village, just the 2 plots of land for which transport was issued. I am saying, by my limited understanding of the law, that could be my Indo ancestral lands. Now translate that to Mr. Roysdale Ford's honorable member, his ancestral land. Where is it? I know that he's from Pike Street, Kitty. It cannot be that his father owned the whole of Kitty. It cannot be, because he upsetting comrade leader. Comrade leader's right there too. And Dr. Luncheon. It cannot be that he's the entire Kitty is his ancestral land. You see, when we want, we do these things, and we, unfortunately, we have other people grabbing on to these concepts and misleading themselves. So this whole concept of African ancestral lands was topical under the previous coalition government. And President Granger, to his credit, established an entire commission to address this concept of African ancestral lands. They had a commission of inquiry. Another one into African ancestral lands. And up to now, we don't know where the report is that speaks to this glorified concept of African ancestral lands. Now, sir, I don't want what I am saying to be in any way misinterpreted. Reference was made, for example, to the village of Victoria, formerly Northbrook. It is a fact it's a historical fact that was the first village bought by the freed slaves. It was Plantation Northbrook. A transport for the land purchased is in existence for that village. And all lands on that transport may be referred to collectively and communally as African ancestral lands, because it is stated in a transport. And those who are championing the rights of Afro-Guyanese, let me tell them today that entire village, sir, that entire village, excepting the persons who went by themselves and obtained prescriptive title for the land that they are occupying individually, those are the only people who have obtained titles individually from that village. The entire village that the Honorable Amanda Desir wants to represent and want to lead people to believe that she's representing their interest. Northbrook, Victoria, the entire village, the people are just living there. Whoever got title for that village, they had to take individual steps to get those transport in their individual names. Not, yes, there's a street in there titled the Bend Street. It's a very straight street. So, sir, not the honorable member is a lawyer. The honorable member is a lawyer. She can easily go in there to help the people regularize their occupation. All of them who are squatting on communally owned lands. She has never done one in her life, but she would come here and create the impression that she's representing the interest of those people. Mr. Speaker, they love to talk about Linden, and I have heard repeatedly my colleague ministers of housing, Rodriguez and Kroll, have repeatedly stated in this house that we have given titles to more people in Linden in 1 year that you have given for the entire country in 5 years. But you would come here and regale the world how you care about Afro-Guyanese. Right now, as I stand here, Numbers 1 village, West Coast Berbice. Number 2 village, West Coast Berbice. Number 3 village, West Coast Berbice. Number 4 village, West Coast Berbice. Number 5 village, West Coast Berbice. 5 Afro-Guyanese villages are being regularized by this administration, where thousands of African Guyanese will get transport and certificates of title. This government is doing it. You can speak about African interests, but you can't stand up, you can't point to one piece of land that you have ever secured for the ordinary Guyanese people. No, well, the honorable member got in Linden, a man said he's here. The honorable Annette Ferguson got 4 house lots. You took for yourself, and nothing wrong with that. But don't pretend here as though you are representing Afro-Guyanese. Lowenfield got 200 acres at Mealy Hideout.
I don't have no 4 house lots.
And another one, another Pan-Africanist leader from the AGDA, he got the whole of 19 village, the seawall front. And the other earth scientist, what's his name? What's the name? Ceres and all these people. These Hopkinson, a gentleman named Hopkinson get 200 acres at Plantation Ogle. 200 acres at Plantation Ogle. Now, these are not ordinary Guyanese. These are not ordinary Afro-Guyanese. These were the friends and families of the coalition government. But when it comes to ordinary Guyanese, you can't point to house lots that you have given. Look, we have at Ansgrove, Mr. Speaker, at Ansgrove.
Honorable member, I remember when the honorable member, Mr. Ford, was speaking, we had a fair amount of silence. Honorable AG, I trust that your colleagues will give you the same silence that they gave Mr. Ford.
Sir, at Ansgrove, another very famous Afro-Guyanese village, the PM, myself, and the Honorable Colin Kroll commenced a regularization exercise where 400 Afro-Guyanese families will get title after 450 years of living there. That is what we do, and we don't have to puff our chests. And
Honorable Member Ms. Ferguson, please. You're now becoming a bit overbearing, even for me.
at the MMA, at the level of MMADA, they took, President Rambutar signed off 50 leases to Afro-Guyanese rice farmers. 50 leases to Afro-Guyanese rice farmers, giving them 10 acres of land each. They went to the bank, they borrowed money, they went to IPED, they took small loans, they bought tractors and credit. And when the coalition government got into government, they revoked all 50 of those leases to give back to members of the PNC. That is what they have done to ordinary Afro-Guyanese. And their court orders. When we were in the opposition, we challenged the revocation of the leases, and we won all 50 cases. And Basil Williams appealed, and he lost all 50 appeal. That is what, yes, that is what we have done for Afro-Guyanese. And that is just a tip of the iceberg. I can go village by village and talk about what we are doing for Afro-Guyanese land rights right across the length and breadth of Guyana. Mocha Arcadia is being mentioned with alarming regularity here. But they will not tell you that after 400 years of Afro-Guyanese living there, today the PPP civic government is regularizing the entire Mocha Arcadia to give them transport and title.
Everything for you is not true.
That is an ongoing project right now. And when we tried to move those who were squatting in the face of a highway, they made that into a big racial issue. They misled 27 people who were in the path of the highway. They tried to persuade 27 of them to stay there. 20 ignored them, and 7 remained. And the 7 had to be forcibly moved because the highway would not have stopped to accommodate 7 squatters. The 20 who were moved, today they live in transported land and they have houses with their families. That is what we have done. We heard about the success squatters. Mr. Speaker, the success squatters that were removed from Gaisuku lands. At Success, 95% of them were Indo-Guyanese. 95% of them, we moved them, they were Indo-Guyanese. Today they want to convert the success squatters into Afro-Guyanese so that they can feed off that narrative. Success and better hope. My constituency, you want to convert them, you want to Africanize them now because they want to feed them into a narrative. So you hear them speak about success squatters. They don't even know who the success squatters are or were. This is diabolical racism, sir. Diabolical racism. So I'm going to get to that. Yesterday, let's go back to the court yesterday. Even without the amendments, you know what? The Honorable Member Royce Ford will bear me out. The judge spoke to the 5 families who were in court. 6 families. And you know what the judge said to them? Look, the government is offering one price and you want another price. You are not challenging the acquisition. You agree that the government should take the land. Your only problem is that the price is different. The government has moved 55 persons, but 5 of you remain. You remain in the middle of a construction site. Power lines have been removed. Piles driving at 100 feet in depth. There's a crane operating that endanger all the lives of you and your family as you sit there. And you want this court to stop that construction so that we can negotiate with you an acceptable price. That is what you want this court to do. That is what you're asking this court to do. You're asking me as a judge to forget the 50 people who have already complied, forget the hundreds of thousands who are going to benefit from this bridge being completed on time. And because you have an issue with the compensation, I as a judge must put the bridge project on hold while I sit with each of you and find out what is acceptable to you. Is that what you want me to do? Can I do that? Would that be in the interest of justice and fairness? That is what the judge said, and Mr. Ford can't deny that. The judge did a mediation session that lasted for nearly 4 hours. Spoke to each member of the family like that and said, tell me what you want me to do. And it is in that, no, he didn't mention many things in his speech. So that is how the judge and that is without the amendments. Without the amendments. The judge said, you are asking me to hold back. Look at the other case. The Honorable Member Kemraj Ramjatan mentioned the other case with Dr. Steve Surajbali. Now we have Steve Surajbali land, and he took us to court because he refused to accept the compensation. Right? Oh yes, and Steve Surajbali, as we all know, is a fellow with big afro here. Right? We know that. And, Mr. Speaker, the entire pipeline to run the gas from the ocean to the gas to shore project, we had to put that on hold until us, the government, and Steve Surajbali work out a compensation package. And they said, that is the law. That is the Constitution. All of us want the blackout to end. All of them want the blackout to end. All of them. They're cussing the government, rightfully so, when they have blackout. They want the blackout to end. They want cheap cooking gas. But we must sit with Steve Surajbali for the next 3 years, put the whole project on hold while we negotiate whether he should get $2 million more or not. Does that make sense? Which constitution of which country will countenance that type of foolishness? Which constitution of which country? That is why, sir, I don't go to the law. I don't go to the law just like that. I reason out because the law is logical. There is no system of law that will allow one human being to hold the public interest at ransom. No system of civilized law will ever do that. And I'm not even going to any law book. I'm reasoning. And that is what the concept of eminent domain is about. And let me read it back again, because we still don't seem to understand. And I'm going to go to the judgments that they're referring to. So, Mr. Ramjatan was speaking about Bhagwati. So let me deal with a man named Durga Das Basu. Commentary on the Constitution of India. Mr. Ford was inviting us to go to India. Commentary on the Constitution of India, 9th edition, 2021. Durga Das Basu, at page 5624, explains the concept of eminent domain thus, and I quote, "The right of the state or the sovereign to its or his property is absolute, while that of the subject or the citizen is paramount." Listen to the distinction. One is absolute and one is paramount. Absolute and one is paramount. I continue. The citizen holds the property subject always to the right of the sovereign to take it for a public purpose. Let me repeat that. The citizen holds the property subject always to the right of the sovereign to take it for a public purpose. This right is called eminent domain, a superior right inherent in society and exercised by the sovereign power or upon delegation from it, whereby the subject matter of rights may be taken from the owner and appropriated for the general welfare. That is the concept. The state's power to take. It is a draconian power. I will be the first to admit that. But that is the nature of the power. It is not contingent upon, one thing it is contingent upon, you must pay compensation. Nothing to do with vacant possession. And let me come to the Constitution now that we are accused of violating. And I want us to listen carefully, Mr. Speaker, because the Constitution has been misquoted by the Honourable Member Cameron Ramjatan and not quoted at all by the Honourable Member Roysdale Ford. Not quoted at all, and there's a reason why. So let's go through the Constitution, Mr. Speaker. No property of any description shall be compulsorily taken possession of, and no interest in or right over property of any description shall be compulsorily acquired except by or under a written law, except by or under a written law, and this is what the written law must do. Listen carefully what the written law must do. Where provisions applying to that taking of possession or acquisition is made by a written law requiring prompt payment of adequate compensation. That the law that authorizes the taking must provide for prompt payment of compensation. There is no requirement here that the state is not entitled to vacant possession. The law that must authorize the taking must satisfy one requirement: prompt payment of compensation. That is the only requirement that the law must satisfy. That is what the Constitution says. And if the honorable members, and I'm challenging them, we can test it. Let them go to the court and let them challenge the law. Let them challenge the law. So great moment has been made of a ruling. Great moment has been made of a court ruling. But Mr. Speaker, in law, we have different judges who interpret law differently. And I'm going to quote the Court of Appeal. Hold on. So, Mr. Speaker, Cameron Ramjatan, honorable member, was on this side of the House in the year 2001 when the government of Guyana, the PPP civic government, acquired a plot of land at Water Street from Tulsi Prasad Limited. Right? Cameron Ramjatan was very much on our side of the bench when we acquired the Tulsi Prasad property. It was done in 2001. 2001, and Tulsi Prasad is another Rastaman. Right, the government took, again, we were threatening Afro-Guyanese ancestral lands when we took Tulsi Prasad land. And we took it to give it to Afro-Guyanese and Indo-Guyanese, but majority Afro-Guyanese vendors vending on Water Street, Georgetown. That's our track record. That is our track record. But the very argument was raised in that case. The very argument about taking of possession and compensation must be paid. And this is what Justice B.S. Roy, who heard the case in the High Court, and Justice Roy is a very experienced judge. He went and he sat in the Court of Appeal for a number of years. And I don't wish to cast aspersions on any other judges, including those who were appointed 2 months ago. I'm not going to cast aspersions on them. But this is a seasoned judge, and this case went to the Court of Appeal. It went to the Court of Appeal, and there's a ruling. Justice Sandil Kisoon made reference to it, and we are looking for it. This case, upheld by the Court of Appeal. Mr. Rex McKay and Senior Counsel Edward Lockhoo argued, and Miles Fitzpatrick, with Doudnat Singh appearing as Attorney General. Justice Roy had to interpret Section 7.1, the very 7.1 of the current law. And this is what Justice Roy had to say, and I quote, "The words, 'the land shall vest in the state,' must be read disjunctively and independently of the words, 'subject to the payment of purchase money or of any compensation as hereinafter provided.'" Let me repeat that so that it sinks in, because understanding is very difficult here. The word, "the land shall vest in the state," that's the very words in the Act, must be read disjunctively, meaning separately, not conjunctively, and independently of the words, "subject to the payment of the purchase money or compensation as hereinafter provided." So the land is vesting in the state, and the payment of compensation is a separate thing. It must be read disjunctively. That is what the judge is saying. I continue. In the first place, it must be emphasized that the whole object of the Act is to facilitate the acquisition of lands required for the public purpose. The whole purpose of the Act is to facilitate the acquisition of lands required for public purpose. There is no other reason for the Act. That is the purpose of the Act. There is nothing consensual, meaning that there is no requirement for there to be an agreement about the provisions of Section 7.1. That's what they are arguing. That you must have compensation. There must be agreement to compensation if title is vested. And the judge is saying, no, there is no such consensual requirement. It is simply coercive, full stop. The words, "the land shall vest in the state," simply mean what they say. It shall vest in the state. That is all that it means. It is nothing short of a statutory vesting declaration. It is unilateral, and it is complete without reference to the expropriated owner. I am not saying so. The private law analogy of the rights of an unpaid vendor has no application or relevance to the provisions of Section 7.1 of the Act. The reference to private law and analogy has no reference at all to Section 7.1 of the Act. All of this is, of course, must not be interpreted to mean that Section 7.1 contemplates or advocates the concept of expropriation without compensation. The judge is saying, I'm not saying that Section 1 means that you can take the land without expropriation. Far from it. Section 1 makes it crystal clear that there must be payment of the purchase money or of any compensation as hereinafter provided. Unquote. That is how judges have been interpreting the same section all the years in Guyana. Mr. Kemraj Ramjatan was on this side of the house when the judge gave that judgment. In 2001. It's not finished. The judge continued. In my view, therefore, who can overrule it? The Court of Appeal upheld this. The Court of Appeal of Guyana upheld this. In my view, therefore, so long as the amount of compensation to be paid to the expropriated owner is not assessed and determined by the High Court in accordance with Section 15 of the Act, the compensation payable by Section 1 of the Act remains at large. So the judge is saying, Mr. Speaker, so long as there is an agreement, or so long as the court has not assessed what the compensation is, the issue of compensation remains at large. But the land is already acquired and possession is already taken. What is at large is the compensation. I am reading from the judgment. You can say what you want. It is only after assessment by the court that the expropriated owner's right to compensation becomes justiciable, claimable, and actionable. The duty and responsibility of the state between the date of vesting of the land and the assessment of compensation by the High Court remains in the nature of an obligation to pay compensation in accordance with the section. That is what we are saying. That's right. That's what we are saying. Are you mentally scarred? What the judge is saying is that the obligation of the state to pay remains intact, but the state must get the ownership and get the possession. That is what the judge is saying. The meaning of the expression subject to therefore. The meaning of the word subject to therefore cannot, in my opinion, be interpreted to mean a condition precedent. The subject to cannot be a condition precedent. To do so would be to cast a wholly erroneous complexion to the section. It would make nonsense of the intendment of the legislation and must be read accordingly. That is what the judges have been ruling. And that is why, Mr. Speaker, all the cases, all the Caribbean territories have that position. They all have that position. And that is why I made reference earlier to Trinidad. I made reference to Belize. I made reference to Barbados. I made reference to Jamaica. And all the relevant provisions are here. In these territories, and Mr. Ford alluded to them, in these territories, the vesting order is not even made as yet, and the state takes possession. The vesting order is not even made, and the state takes possession. And they have a constitution that is identical to Guyana. The constitution of these countries, oh my God. The constitution of Trinidad, the constitution of Belize, the constitution of Jamaica are almost identical in their protection to private property, like the constitution of Guyana. And all these provisions, they empower the state to take possession long before title is vested, in keeping with the concept of eminent domain. Now, if you don't understand the concept of eminent domain, well, then you will not understand the unusual power that the state has. And I can't teach those who are incapable of understanding what eminent domain means. You want to distort the concept of eminent domain. That's what they want to do. So, Mr. Speaker, as I said, it is open to the honorable members to go to the court. Mr. Ford has a long history of winning many cases against me from 2020 to now. We can continue that record. Pandit Ram Kisun and Pandit and Brong, Sarah Brong, are here testimony to his legacy in the courts. They are here today. So it is open. It is open for them to challenge it. And we will go and argue it. We will go and argue it. I wouldn't challenge the Honorable Member Walton Desir to go to court. She's an attorney at law, but I've never seen her anywhere close to a court. Anywhere close to a court. So I can't challenge her. But Mr. Roysdale Ford is an eminent senior counsel. The Honorable Comrade Ramjatan told us that he appeared in many, many cases like this. And I asked him just to name one, and he couldn't name one. He couldn't name one, but he told us he appeared in many of these cases, and he couldn't recall one. Poor Honorable Member. There were so many. There were so many. But, Mr. Speaker, oftentimes we are asked in this Parliament to work together, and we are asked to trust each other. And I want to conclude by reciting what transpired yesterday. Because we met in good faith. We met in good faith. Honorable Member, whose birthday we are celebrating, Chris Jones, texted me in the morning to ensure that the meeting is still on. And I gave him a thumbs up because I was in court. And they turned up at the office of the AG office. Mahi Paul was there, the Honorable Member. We had to wait about 20 minutes for Mr. Ford. Miss Annette Ferguson was there. Honorable Shara Duncan was there. And Vincent Henry. Was Amanza there? No. We were told Amanza was fighting to come, but from directions upper, she was told not to come. A bird whispered that information to me. She got dressed and everything, Mr. Speaker, I was told. She got dressed and everything. And I mean, I felt for her because she does dress well. Would have taken a lot of effort. And then to be told that you can't attend the meeting is rough. It's rough. But we met. We met and throughout the meeting, Dr. Ashley Singh, everything, Mr. Ford. Well, first of all, we agreed on Section 7 after some discussion that we are not going to change Section 7. And Mahi Paul was raising some arguments, and Ford, to his credit, overruled the arguments. And if you hear Annette Ferguson, right through, yes, yes, Roysdale, yes, Roysdale, right through. If you see, I've never seen her so animated, yes, you all can do that, That's the extent of her contribution, yes. And when Roysdale changed his position, yes, Roysdale, you're right. Yes, Roysdale, you're right. That was the extent of the Honorable Member's contribution to the meeting. Right? And I am not, Annette, you will be, I mean, I'm not misrepresenting you. I am not. Any meeting I go, I want a disciple like that to follow me. I want a disciple like that. I could never go wrong. Lovely. Aubrey, you want a disciple like that too. Yeah. When Mr. Ford raised the thing about interest, how could the Minister of Foreign Affairs, Minister of Public Works determine who is an interested party? I mean, the Honorable Member said, you want to put the bishop in that position because people will come with different interests. More people would claim they're, 2 or 3 people may be entitled. How the bishop will decipher that? Hey, Raned. Oh my God, you want to do? Don't put the bishop in that position. The Honorable Member was here.
Mr. Speaker, I just want to place on record what the Honorable Member's reporting is not true.
We had a very, very productive engagement. To sum it up, very productive engagement. Mr. Ford, he said to me, okay, well, let's move on from Section 7. We will leave Section 7 as it is. That's the man's position. Of course, and I said, yes, Roysdale, let me move on. And that was, I hear the presentation today how Section 7 is so horrendous. And Mr. Ford said, yes, let's deal with the compensation then. And let's put the power in the court. Let the minister lodge the money in the court and lodge it immediately when the state takes possession. Yes, Rising, let's feel. Yes, yes, AG. That sounds right. The Rising say, what? Here, let's put it with the registrar. Let's say yes, the registrar. Yes, the registrar. Yes. And she pronounced it the last syllable of whatever Rising say. Like she didn't say registrar, she said rar. He said regis and she said rar.
Mr. Speaker.
Any one of them could stand up and contradict me.
Mr. Speaker, I stand on a point of order.
Go ahead, honorable member. Forte A or B?
I probably, Mr. Speaker, if we can use both, I don't mind support going to for both Forte A and B. But I just
Honorable member, the point of order. Honorable AG, you can continue.
So, sir, I detain the House, sir, to depict accurately the atmosphere of camaraderie and cooperation that permeated the meeting. And that's why I'm shocked here to hear that this thing is contentious. In fact, I will challenge the Honorable Member Mahipal. At the conclusion of the meeting, you know what Honorable Member Mahipal said? We can finish the parliamentary sitting at 10 minutes after 10. Because this is the only thing that we are contesting. 10 minutes after 10, he said. Did you not say so, Honorable Member? He said there is nothing to debate. There is nothing to debate because they agree with everything. And we could have an early day. No, a man said they zero overturn them. When she makes her. At the end of the meeting, while they were having a private smoke, I saw the Honorable Member Ganesh complimenting Minister Teixeira and said we should really meet more often, Gail. And they shared a mint. Gail gave him a mint and he sucked away liberally.
Honorable AG, you've effectively consumed your 45
yes, sir.
Initial minutes
so, sir,
in concluding. You may need an extension to continue.
A lot.
Mr. Speaker, may I ask that the AG be allowed to continue?
Thank
Give
you,
you the standing
AG, you may
orders.
continue.
So, Mr. Speaker, I want to conclude by assuring the people of Guyana that there is nothing untoward, there is nothing adverse about this bill. The state had the power in any event to take vacant possession. That is how the law was being interpreted all the time. There has been an interpretation that has gone against the grain. And Honorable Member Mr. Ford has made mention to it. The people of this country, Mr. Speaker, has to choose, importantly. We have, Mr. Speaker, to end blackout. To end blackout, we have to, within the next year, acquire over 200 pieces of private properties across this country. To complete the road works scheduled for the next year, we have to acquire a lot of pieces of property. And the truth is that the people of Guyana are anxious for development. Anxious for development. And they will choose. Do we want blackout to end? Do we want blackout to end? Or we want blackout to continue while one or two persons detain a process over adequacy of compensation? The law, Mr. Speaker, will not be legal. The law will not be legal unless it guarantees adequate compensation to be paid promptly. The law will be illegal if it doesn't do so. And we are saying that the law in its current form as amended by this bill satisfies those requirements. Mr. Speaker, with those few words, I ask that this House pass this bill as printed. Thank you very much, sir.
Thank you very
Thank you.
much, Honorable Attorney General. Honorable members, I now put a question that the Acquisition of Lands for Public Purposes Amendment Bill 2024, Bill number 16 of 2024, be read a second time. Those in favor say aye. Those against say no. Ayes have it. Let the bill be read a second time.
Acquisition of Lands for Public Purposes Amendment Bill 2024, Bill number 16 of 2024.
Honorable members, we will now resolve ourselves into committee of the whole to consider the clauses of the bill. Honorable members, we are now in committee. The bill has 3 clauses and we have 2 amendments. And I now propose the question that clause 1, as amended, stands part of the bill. Honorable Attorney General, you want to make an intervention there on that amendment?
I'm sorry, sir. You lost me there.
Okay.
Oh. Yes, sir. Sir, I move that the amendments as circulated be passed as printed.
So we have first, your amendment was clause 2. Insert after clause 2 the following as a new clause 3. And that clause 3 reads, Section 12(1) of the Principal Act is amended by substituting for the
Yes,
words.
sir.
So that's the new
That's the
clause
new clause
2.
3.
Right? New clause 3, sorry. Right? So that's the new clause 3. I propose, first, let me propose that clauses 1 and 2 stand part of the bill. I put the question that clauses 1 and 2 stand part of the bill. Those in favor say aye.
Aye.
Those against say
Division.
no. Honorable member, Mr. Jones.
Division.
I had just proposed the question. I have to put before you get the division. So I now put a question that clauses 1 and 2 stand part of the bill. Those in favor say aye. Those against say no. Ayes have it. Do I hear the call, Mr. Jones? Honorable member?
Division, please. Division.
Division on clauses 1 and 2 being part of the bill. The division, let's ring the bell and take 5 minutes for members to get in place.
We need more guidance.
Yes. Clauses 1 and 2.
This is 1 and 2. We have a problem with this part alone. We are supporting.
Honorable members, we will have to go clause by clause, and even because the honorable member, Mr. Jones, is not objecting to clause 1. He wants the division on clause 2, in particular section C. So let me seek the clerk's advice. Can we go back? Honorable members, I now put a question that clause 1 stand part of the bill. Those in favor say aye. Those against say no. Ayes have it. Clause 1 now stands part of the bill. I now put a question that clause 2 stands part of the bill. Those in favor say aye. Those against say no. Ayes have it.
Division.
There's a call for division. Let's ring the bell. Get everyone in place. 5 minutes.
Mr. Chairman, is it number 2 going to be broken down to A, B, and C?
Clause 2. The whole clause.
The whole clause will be,
Yes.
well, we are not objecting to the whole clause. We want A, B, and we support, and C we are not supporting.
We
We can't
The
do it that way.
convention is we put the entire clause,
Okay.
not a section of the clause.
No, well, that is the trouble.
And when I was proposing, you could have proposed an amendment. No, it's only 2 minutes. Let's just give another 2 minutes.
Dr. Kisoon? Dr. Kisoon? Mr. Sears? Mr. Sears?
No, no, no.
Mr. Sinclair?
No.
Miss Alert?
No.
Miss Philadelphia?
No.
Mr. Jai Prashad? Mrs. Flubes?
No.
Mr. Rajkumar? Mr. Rajkumar?
No.
Mr. Mahipal?
No to 2C.
Mr. Figuera?
No.
Mr. Cox?
No.
Mr. Patterson? Mr. Patterson? Mr. Patterson?
Don't recognize that voice. One more time.
Mr. Patterson?
Move on. No.
Miss Finance?
No.
Ms. Ferguson,
No.
Mr. St. Louis,
No.
Mrs. Sirabu Hali,
No.
Dr. Cummins,
No.
Mr. Henry,
No.
Mr. Ramsarup, Mr. Ramsarup, Miss McDonald, Miss
No.
McDonald, Mrs. Walton Desir,
No.
Mr. Jordan,
No.
Mr. Jones,
No.
Mr. Jones,
No.
Mrs. Hastings Williams,
No.
Mrs. Lawrence,
No.
Mr. Duncan,
No.
Mrs. Chandan Edmond,
No.
Mrs. Hughes,
No.
Mr. Holder,
Class 2C, no.
Mr. Holder,
Class 2C, no.
Mr. Ford,
No.
Mr. Ramjatan,
No.
Mr. Norton,
No.
Excuse me, I was voting and talking and I was not being heard.
Mr. Clerk, you didn't ask me. You didn't ask me.
Nor did he record my vote.
so put her,
Mr. Speaker, Mr. Speaker, you didn't ask me. You didn't ask me.
so Patterson.
No.
I want to vote.
Mr. Skunja,
I said no as well.
Yes.
Clerk,
What's going
I would
on?
like my vote to be recorded.
Mr. Patterson, we heard you
I wasn't
afterwards.
asked.
Yes.
Mr. Speaker, my name wasn't called. My name wasn't called.
yes.
Yes, it was. Yes, it was.
I didn't vote.
You answer. You
And have
vote.
you, yeah. And have him vote
Please
again.
call back Mr. Ford. He didn't hear.
Mr. Ford, Mr. Ford,
No.
Mis-
No.
I said no as well.
Mr. Patterson, you're recorded as no. Sherwin.
Thank you very much, sir.
And Mr. Holder, we did hear you. Yes.
Miss Kunja, Miss Kunja,
Yes.
Miss Veersamy,
Yes.
Mr. Williams, Dr. Smith,
Yes.
Mr. Jaffer Ali, Dr. Westford, Dr. Ramsaran, sorry. Mr. Spearson Fredericks,
Yes.
Mr. Narayan,
Yes.
Mr. Datadin,
Yes.
Dr. Mahadio,
Yes.
Mr. Charlie,
Yes.
Mr. Siraj, Mr. McCoy, Mr. A. Prasad, Mr. Indar, Ms. Rodriguez,
Yes.
Ms. Parag,
Yes.
Mr. Ramson,
Yes.
Dr. V. Prasad,
Yes.
Mr. Kroll, Mr. Bharat,
Yes.
Mr. Hamilton,
Yes.
Ms. Sokai,
Yes.
Mr. Mustafa,
Yes.
Mr. Mustafa, Mr. Manik Chand, Dr. Anthony,
Yes.
Bishop Edgel, Mr. Todd,
Yes.
okay. Mr. Shearer,
Yes.
Mr. Nandlal,
Yes.
Mr. Jagdeo, Mr. Jagdeo,
Okay, still one.
Mr. Jagdeo, Mr. Phillips,
Yes.
So we still have one.
Dr.
Aye.
Mr. Mr. 30. Change this to 30.
Mr. Speaker, 30 members voted against the motion, with 33 voting in favor.
The motion is carried. Honorable members, I have I have another amendment, and this is a new clause 3, and I propose the question that the new clause 3 stands part of the bill. I now put the question that the new clause 3 stands part of the bill. Those in favor say aye. Those against say no. Ayes have it. The new clause 3 now stands part of the bill. Honorable members, I now propose the question that the amended clause 3, which is now the new clause 4, stands part of the bill. I now put a question that clause 4 stands part of the bill. Those in favor say aye. Those against say no.
Division.
Ayes have it. There's a call for division.
Division.
Let's ring the bell.
Anil, who come out to this meeting yesterday? Who come out to this meeting when you started this morning? You said such glorious things.
Shut up, Mr. Clerk.
Dr. Kisoon? Dr. Kisoon?
One more.
Dr. Kisoon?
Aye.
Mr. Sears?
No, no, no.
Mr. St. Clair?
No.
Miss Alert?
No.
Miss Philadelphia?
No.
Mr. Jai Prashad? Mistress Flubes?
No.
Mr. Rajkumar?
No.
Mr. Mahi Paul?
No.
Mr. Figuera?
No.
Mr. Cox?
No.
Mr. Patterson?
No.
Miss Finance?
No.
Miss Ferguson?
No. No.
Mrs. Singh Lewis?
No.
Mrs. Sarabu Hali?
No.
Dr. Cummins?
No.
Mr. Henry?
No.
Mr. Ramsarup? Mr. Ramsarup?
One more time.
Mr. Ramsarup? Miss McDonald?
No.
Mrs. Walton Desir?
No.
Mr. Jordan?
No.
Mr. Jones?
No.
Mrs. Hastings Williams?
No.
Mrs. Lawrence?
No.
Mr. Duncan?
No.
Mrs. Chandan Edmond?
No.
Mrs. Hughes?
No.
Mr. Holder?
No.
Mr. Ford?
No.
Mr. Ramjatan?
No.
Mr. Norton?
No.
Mr. Skunja?
Yes.
Miss Veerasamy?
Yes.
Mr. Williams?
Yes.
Dr. Smith?
Yes.
Mr. Jaffer Ali?
Yes.
Dr. Westford? Dr. Ramsaran?
Aye.
Mrs. Pearson Fredericks? Mrs. Pearson Fredericks?
Yes.
Mr. Narayan?
Yes.
Mr. Datadin? Dr. Mahadio? Mr. Charlie?
Yes.
Mr. Siraj? Mr. McCoy?
Yes.
Mr. A. Prasad?
Yes.
Mr. Indar?
Yes.
Ms. Rodriguez?
Yes.
Ms. Parag? Mr. Ramson?
Yes.
Dr. V. Prasad?
Yes.
Mr. Kroll?
Yes.
Mr. Barat? Mr. Hamilton?
Yeah.
Ms. Sukai?
Yes.
Mr. Mustafa? Ms. Manik Chand? Dr. Anthony? Bishop Edgel? Mr. Todd?
Yes.
Mr. Shearer? Mr. Nandlal?
Yes.
Mr. Jagdeo?
Yes.
Mr. Phillips?
Yes.
Huh? I got 36.
Mr. Speaker, 30 members voted against the motion, with 34 in favor.
Honorable members, the motion is carried. Clause 4 now stands part of the bill. Honorable members, I now put a question that the bill be reported to the Assembly. Those in favor say aye. Those against say no. Ayes have it. Let the assembly resume. Honorable Attorney General and Minister of Legal Affairs.
I rise, Mr. Speaker, to report that the acquisition of lands for public purposes Amendment Bill 2024, Bill number 16 of 2024, was considered in committee clause by clause and was passed with amendments. I move that the bill be now read the third time and passed as amended. Thank you.
Thank you, AG. Honorable members, I now put a question that Bill number 16 of 2024, Acquisition of Lands for Public Purposes Amendment Bill 2024, be read a third time and pass as amended. Those in favor say aye. Those against say no. Ayes have it. Let the bill be read a third time.
Acquisition of Lands for Public Purposes Amendment Bill 2024, Bill number 16 of 2024.
Honorable members, we will now move to the second reading of the Security Interest in Movable Property Bill 2024, Bill number 20 of 2024, first published on the 27th of November 2024. The Honorable Minister of Tourism, Industry and Commerce, the Honorable Onej Walran.
Mr. Speaker, I rise to move that the Security Interests in Movable Property Bill 2024, Bill number 20 of 2024, published on the 27th of November 2024, be now read a second time. Mr. Speaker, the Security Interest in Movable Property Bill is a critical piece of legislation that will pave the way for creating a modern, inclusive, and efficient system for secure lending in Guyana. It represents another milestone in our journey to transform Guyana's economic landscape by fostering financial inclusion, empowering small and medium-sized enterprises, and increasing access to credit. Currently, Mr. Speaker, our secure transactions framework is outdated and fragmented. Guyana currently lacks the centralized system for managing these kinds of secure transactions involving movable property. And this absence has created several challenges. First of which, obviously, Mr. Speaker, is that there's a barrier to credit access. Without this system, lenders, particularly commercial banks, are hesitant to provide loans to businesses unless immovable properties such as land and real estate is offered as collateral, sidelining movable assets as viable security. This bill now seeks to remedy this. The bill also addresses the problem of limited access to credit for SMEs and low-income individuals. Many SMEs struggle to access credit, Mr. Speaker, because they are often considered high risk by borrowers due, of course, to insufficient or inadequate collateral. Commercial banks are therefore reluctant to extend loans to SMEs who do not have tangible, immovable assets. Further, Mr. Speaker, a significant amount of our population would be excluded from accessing financial services because they do not own immovable property, further limiting their economic opportunities. The existing laws governing movable properties are dispersed across multiple acts, making the system cumbersome and discouraging lenders and borrowers alike. Additionally, registration and enforcement processes for secure transactions involving movable property are time-consuming, costly, and complex, further discouraging the use of assets as collateral. There is no provision under existing laws to recognize and use modern personal assets, such as intellectual property or digital assets, as collateral, despite their significant value. This gap stifles innovation and limits opportunities for entrepreneurs and the creative industries in Guyana's rapidly growing economy. So, Mr. Speaker, this bill seeks to resolve these issues by introducing a comprehensive, modern, and inclusive legal framework to govern security rights in movable assets. Its primary goal is to modernize Guyana's secure transaction system, addressing inefficiencies and creating a unified, efficient, and technology-enabled structure aligned with international best practices. By consolidating fragmented legal mechanisms, the bill simplifies the process of using movable assets as collateral for secured credit, making credit more accessible to a wider range of borrowers. The bill does not introduce radical changes to policy, but builds on long-standing legal and commercial principles. It adapts these principles to modern financial realities, ensuring consistency with established practices while introducing much-needed updates. The bill fosters greater efficiency, transparency, and legal certainty in credit markets by streamlining the secured transaction system. Under this framework, all movable property assets can qualify as collateral, irrespective of their type. These include tangible assets like equipment, inventory, crops, livestock, and vehicles, as well as intangible assets such as receivables, intellectual property, and negotiable instruments. This expanded scope allows borrowers to leverage a diverse range of personal and business assets for credit, creating new opportunities for financing. The bill consolidates previously fragmented mechanisms for securing credit, such as bills of sale, finance leases, and pledges of goods, into a single legal device called security agreements. These security agreements are consensual agreements securing the payment or performance of obligations. This shift eliminates redundancies, reduces administrative burdens, and ensures a coherent legal framework for secure transactions in Guyana. Mr. Speaker, while there is no radical shift in the underlying policy, this bill introduces several transformative measures designed to improve the lending and borrowing landscape, particularly for movable assets. Permit me to highlight the key provisions that will reshape the way security interests are created, registered, and enforced. In Clause 2, which speaks to the scope of the application, the bill applies to various types of security interests, including liens created by judgment or law, transactions that create a security interest regardless of form, finance leases, commercial consignments, long-term leases of goods, and outright assignments of intangibles. However, it does not cover rights of set-off, certain land-related transactions, wages, annuities, tort claims not tied to commercial activities, or specific transactions like these involving ships or certain license where security interests are prohibited. Additionally, security interests registered under the Companies Act remain governed by the provisions of that act and are excluded from the provisions of this bill. Part 3 and Part 4 provides for the security interest it provides that a security interest is a property right in movable assets created to secure the payment of a performance or an obligation. It arises through a security agreement between the grantor, that is the debtor, and the secured creditor, the borrower and the creditor. The agreement must be in writing, signed by the debtor, and specify both parties along and specify both parties along with the secured obligation. The collateral must be described in sufficient detail, either by specific listing, category, or type of asset. The agreement can secure both present and future obligations and may apply to specific movable assets, categories of movable assets, or all of the debtor's movable property. If the property or asset is jointly owned, all owners must sign the agreement. Section 10 provides that the description of the collateral must be specific enough to identify it in order for it to be enforceable. And the debtor has to have the rights in the collateral. So you can't sign an agreement with a movable property or collateral that doesn't belong to you. To perfect the security interest, the agreement must be registered, or the creditor must take possession or control of the collateral. Perfection ensures that the creditor's rights are enforceable against third parties and remains valid as long as there are no gaps in registration or possession. Section 11 speaks to the perfection of a security interest. Perfection is basically the process of making a legal claim to a debtor or a borrower's property enforceable against a third party. It gives the secured person priority over an unsecured party in event of the debtor's insolvency. Parts 2 and Parts 8 speaks of the registration of the security and interest. Because, Mr. Speaker, there is a requirement that it has to be registered in order for it to be, the security interest to be perfected, that is enforceable. The registration of security interest in movable property is managed through an electronic register maintained by the registrar. Clause 46 provides that when registering security interest, an initial notice must be submitted, which includes details about the debtor, secured creditor, collateral, and the term for which the security interest shall be effective. Once entered into the register, the notice becomes effective and is assigned a registration number. The registration can be amended or renewed as necessary, and any errors will not invalidate it unless they are significantly misleading. The electronic register allows for real-time registration and public access to information on existing claims, reducing inefficiencies of the previous manual process. Through the registry's priority system, lenders can determine the order of claims with priority given to the first registered interest. This ensures greater transparency, reduces disputes, and creates a more efficient credit system. A predictable priority system will determine the ranking of the claims, fostering, of course, trust in the lending process. Clause 10.4 provides that once the initial notice is registered, the security right becomes valid against third parties. This protection also extends to proceeds from the collateral, such as monies or receivables, with automatic protection for certain types of proceeds. For others, the creditor must update the registration within 10 days to maintain the protection. Part 6 and 7 establishes the priority system. The priority among competing security rights is determined by the time of the registration of the initial notice. The bill establishes that a non-consensual creditor can only gain priority by registering their notice before the security right takes effect against third parties. Additionally, a possessory lien on goods takes priority over security right as long as the lien holder retains possession of the goods. The bill also introduced a principle of an innocent purchaser, ensuring that buyers who are unaware of existing security rights can acquire collateral free of those interests. Part 9 provides that if a debtor is in default, a secured creditor can take possession of the collateral or render the collateral unusable. This is in accordance with Section 64. This section provides remedies for enforcement of the security interests, a very important part of the section, Mr. Speaker. Section 63 provides for the general principle of enforceability. It provides, and I read, that if the debtor is in default, a secure creditor may A, take possession of the collateral, or B, without removal, render the collateral unusable in accordance with Section 64. A secured creditor may proceed under this section to 1, judicial process, A, or B, without judicial process if the debtor does not resist the removal of the collateral. The commencement of enforcement requires registration of the enforcement form, which will identify A, the debtor, it will identify the secured creditor, and it will identify the collateral against which enforcement is sought. Section 63.4 provides a prior notice to the debtor is not required for the secured creditor to repossess or render the collateral unusable under this section. The enforcement process can involve the sale of the collateral either through auction, private sale, or tender. Creditors must notify interested parties of the sale, except in cases where the collateral is perishable or an immediate sale is required. After the sale, the creditor must provide a statement of account detailing the proceeds, costs, and any remaining debt. The proceeds from the sale are used first to cover the costs of the sale, followed by payments to subordinate creditors, with any surplus returned to the debtor. Additionally, creditors may propose or retain the collateral in satisfaction of the debt. But if objections arise, the collateral must be sold. The bill also outlines the right of debtors or entitled parties to redeem the collateral by curing defaults before the sale. Section 11 provides for the repealing of the Livestock Loans for Development Act and the Bills of Sale Act, as well as sections 10, 11, 12, 13, and 17 of the Pledge of Goods Act. Section 95 provides that any prior security interest that was enforceable against third parties under the previous law will remain enforceable against third parties during the transitional period under the bill. Section 94 identifies that this transitional period is a period of 6 months beginning at the commencement of this act. The bill also outlines how other security interests may be considered perfected during the transitional period and addresses the priority of prior security interests during this time. So the bill provides for things like bill of sale, how to treat with the transition and to register those kinds of interests in safe vehicles. If a security interest is not perfected under this bill within the transitional period, it will be deemed imperfect. Mr. Speaker, the specific benefits and importance of the bill, the benefits of the bill are many. Access to credit is essential for economic growth. Without it, businesses struggle to invest, struggle to expand, and they struggle to compete. For borrowers, this bill is transformative. It allows them to use movable property, such as personal and business assets, as collateral. Even if you don't own immovable property, borrowers can use the same collateral for multiple loans, following the priority rules. This is specifically beneficial for small and medium enterprises and individuals who often face challenges in accessing credit due to insufficient collateral. The bill, therefore, promotes financial inclusion, enabling more people to participate in the formal credit market. For lenders, the bill creates a more secure and predictable lending environment. It reduces risk. It establishes clear rules for enforcing security interests and recovering debts in the event of borrower default. The priority system ensures orderly ranking of lenders' claims to collateral, reducing the risk of disputes. This clarity and security make it more attractive for lenders to extend credit to individuals and businesses they might otherwise consider too risky. The bill enables borrowers to access larger loans, longer repayment periods, and lower interest rates. Studies have shown that countries with robust, secure transaction laws see increased credit availability, with credit rising as a percentage of GDP. The bill provides certainty to lenders by establishing a well-defined process for registering and enforcing security interests in movable assets. This lowers risk, as I mentioned, especially in high-risk sectors like oil and gas, where large investments are common. It is worthwhile mentioning, Mr. Speaker, that women and vulnerable groups, when this bill is enacted, will see great relief, as it will assist women-owned businesses to overcome barriers to credit, further fostering financial inclusion and enabling them to contribute to Guyana's economic growth. It provides also access to the formal markets. One of the great challenges we have with small and micro enterprises is the fact that they operate informally. And this bill continues to encourage these businesses to formalize their operations, reducing reliance on the informal sector. The bill also allows for use of receivables as collaterals for loans. This is especially useful in sectors with long payment cycles, allowing businesses to access liquidity before payments are received. By pledging receivables, companies can secure short-term finances for operational costs or bridge funding gaps. The bill diversifies credit sources by encouraging non-bank financial institutions and reduces reliance on real estate collateral, rendering financial systems less vulnerable during crisis. It establishes a predictable priority system. Additionally, it strengthens our financial infrastructure, including collateral registries and risk management systems, promoting better reporting and informed credit decisions. Mr. Speaker, this bill was drafted with positive reference points. Several countries, such as Mexico, Ghana, and Colombia, have adopted similar secure transaction regimes and have witnessed remarkable increases in lending to SMEs and underserved communities. In Ghana, for example, small businesses and farmers face significant challenges accessing loans due to reliance on immovable property. A movable collateral registry was introduced in 2010, allowing businesses to use machinery, vehicles, and accounts receivable as collateral. In the first year of implementation, there were over 40,000 movable collateral registrations in the first year alone, increasing access to farmers and small businesses in rural areas. In Honduras, like many developing economies, businesses lacked access to credit due to collateral requirements favoring real estate. In 2010 as well, Honduras implemented a modern movable collateral framework and a simple low-cost registry system. This resulted in more than 90,000 loans being secured using movable assets in the first 3 years. 60% of loans benefited small businesses and women entrepreneurs. In particular, gained access to credits as movable assets like inventory and equipment were accepted as collateral. These source documents are from the World Bank. In 2013, Jamaica implemented their secure transaction system, which had a transformative impact on the business and financial environment, particularly once again for small and medium-sized enterprises. MEs in sectors like agriculture, manufacturing, and retail have seen tangible benefits. For example, Jamaican farmers and shop owners can now use livestock, equipment, or inventory as collateral to secure loans, driving economic growth in underserved communities. Last year, St. Lucia, another CARICOM member state, successfully implemented its collateral registry of movable assets, and is expected to enhance economic opportunities, particularly for self-employed individuals in the tourism sector. Before I conclude, Mr. Speaker, I wish to assure this Honorable House that this bill comprehensively represents the thoughts of many stakeholders, thoughts gathered during a suite of consultations. The bill underwent a series of consultations starting in 2018-2019, with input garnered from stakeholders in Georgetown, Essequibo, and Berbice, recognizing the significant importance of the Security Interest in Movable Property Bill 2024 and its potential to transform the legal and financial landscape. The government prioritized ensuring the bill's effectiveness and relevance. In 2021-2022, further consultations were conducted alongside comprehensive technical teamwork by a team of experts to ensure the bill addressed the needs of all stakeholders and aligned with international best practices. In 2023, the Ministry of Legal Affairs, in collaboration with the Ministry of Tourism, Industry and Commerce, reviewed and incorporated a recommendation gathered during the consultations and from legal technical experts. The final version of the bill was completed in January 2024 and sent out to stakeholders for final review in May 2024. This process of continued review and refinement demonstrates government's commitment to getting the bill right, ensuring its success. The bill was first read in the National Assembly on the 27th of November 2024. Mr. Speaker, in conclusion, with the passage of this bill, Guyana can now join this progressive global movement to modernize our financial system and support inclusive growth. This bill represents a forward-looking, pragmatic solution to a long-standing challenge. It is testament to this government's commitment to economic diversification, poverty reduction, and national development. As Guyana economy continues to grow, we must ensure that all Guyanese can share in the benefits of our prosperity. By creating a robust, secure transactions regime, we are unlocking the potential of our people, our businesses, and our country. I therefore urge all honorable members, Mr. Speaker, to support this bill, which will enhance the environment for the inclusive, innovative, and resilient Guyanese economy that we are working to build. Thank you, Mr. Speaker.
Thank you very much, Honorable Minister Warren. And now I invite the Honorable Comrade Ramjitan to make his contribution.
Thank you, Honorable Mr. Speaker. I immediately want to put on the public record that what Minister Munij Waldron has indicated as the reasons behind the bill and its purpose, and of course its larger commercial purpose in enhancing the ability for especially small businesses and persons involved in businesses to secure credit, do find attraction on this side of the house, and quite frankly, we're going to support it fully. I want to, however, shed some concerns of mine, and that has to do with the commercial registry. There will be need, in view of the fact that we're going to have the registration of so many and in various forms of registration, what is called these movable properties, and they can range from a car or a motorbike right down to tractors and even crops that are still to be cut. And so whatever will be the documentation that has to be registered, and I understand it will be in electronic form, certainly will need far more resources in our commercial registry. And of course, one that is functional and not one whereby, like we have suffered as lawyers in the registry over some periods of time, where transports may not have the annotations in relation to certain matters agreements and liens and mortgages, and you go and you check out there the registry and you find certain things happening that are not accurate. It's the accuracy of the commercial registry and what it will have in its electronic version that is going to make a system like this work very well. And so I hope that the necessary resources and the necessary personnel to ensure the functionality of this new institution that we're creating will be on stream. The other concern I have is a review that might be required as to how the lenders are dealing with the debtors. That's always a difficulty. We have seen the advantageous positions of lenders as against creditors, and by the end of the time period for repayment, it does not happen, then the tractor will be seized or the movable property will be seized, and you have a tremendous amount of discord that emanates from the debtor. And you might very well have what is called an imbalance in relation to he who is lending the credit as against he who is borrowing. And by the time the year is ended, we get a man lose his tractor, he combine and everything. So we got to be very cautious. And as a government, I am urging that Minister Anik Waldron keep abreast in relation to what's happening there as to whether we will having, as Dr. Chedi Jagan used to talk about, usurious zamindars taking charge of legislation like this and literally taking away the people's property because of a number of legalistic approaches they might have in relation to the perfection of all these things in the registry and so on. And it could be, of course, disadvantageous to the poor, which this bill, in my opinion, seeks to direct credit to. In addition, the third concern has to do with the burgeoning litigation that might be forthcoming out of this institution of movable property security interest. Every bill that comes to Parliament with this infrastructure requires sometimes initially a number of cases being brought. And of course, we have a situation where the High Court will be dealing with a number of cases, and in that context then, we will need the courts to make rulings. I understand that we have appointed a number of High Court judges recently. We probably will need to see the Court of Appeal judges being appointed so that at least this additional rush of cases that might come on within a year or two in relation to the provisions of this Act, that we can cater for them. So those 3 points I wish to make as concerns, and hopefully Honorable Minister and his cabinet can take them in good stead. I do not mean to oppose in any way. This is welcome, and the concerns, however, are what I would want to see always being reviewed and addressed. I support, and the opposition support, this bill. Thank you very much.
Thank you very much, Honourable Member, Mr. Ramjathan. I will now call on the Honourable Dr. Ashley Singh, Senior Minister, the Office of the President with responsibility for finance and public service. Honourable Minister.
Thank you very much, Mr. Speaker. I rise to add my my own voice of support to the contributions that have already been made earlier in favor of the security interests in Movable Property Bill 2024. Mr. Speaker, my colleague, Minister, the Honorable Minister Onej Walrond, the proposer and mover of the motion in favor of this bill, has already articulated in abundant and adequate detail the merits, the basis for, and the merits of the bill. And I am myself pleased, as I'm sure we all are in the House, to hear the supportive contributions offered by the Honorable Comrade Ramjatan, also in favor of the bill. I wish, Mr. Speaker, only to make the following observations: that this bill represents the latest installment in a long sequence of legislative and other interventions made by this People's Progressive Party civic government and predecessor People's Progressive Party civic governments in strengthening the financial sector, an effort that we have been making over time in recognition of the very important and very strong symbiotic relationship between economic growth on the one hand and financial sector development on the other, a matter that Minister Walrond addressed in her presentation. And so over time, we have seen our government bringing to this parliament and enacting modern central banking legislation, the Bank of Guyana Act and its subsequent amendments, modern financial sector legislation, in particular the Financial Institutions Act, initially in 1995, and subsequent amendments to lay the foundation for strong regulation and supervision of financial institutions in our country. An initial Money Laundering Prevention Act and subsequent Anti-Money Laundering and Countering the Financing of Terrorism Acts to lay the foundation for what we now have, which is a robust anti-money laundering framework, a framework, incidentally, that was just commended through the Caribbean Financial Action Task Force mechanism. Legislation to regulate other subsectors of the financial sector, such as the Money Transfer Agencies Act, the Credit Reporting Act, the Compliance Commission Act, all comprising critical elements of a comprehensive legal architecture, which in turn would establish a robust institutional architecture for a strong, well-regulated, strong and stable and well-regulated financial system. I might add, of course, that we have, through the regulators, in this instance, the central bank, we have issued a vast array of guidelines in support of the legislation, here again to ensure a strong financial sector, guidelines that address licensing of financial institutions, branching, credit exposure review and classification, provisioning, acquisition of control of financial institutions, limits on large loans and loans to shareholders, directors, and other related parties, corporate governance, risk management, technology risk management in particular, and the list goes on, a comprehensive array of supervisory guidelines, here again to preserve the integrity and strength of financial institutions operating in our financial sector. We have also, of course, enacted legislation to improve the effectiveness, the efficiency and effectiveness of the market for credit, including in new and emerging and non-traditional forms of credit, including the Hire Purchase Act, which this Parliament enacted not so long ago. We've enacted legislation to promote more affordable legislation and implemented other policies to promote more affordable access to credit, including the special provisions in relation to the low-income housing window, which has enabled banks to provide more affordable credit for home ownership, the introduction of mortgage interest relief and the restoration of the ceiling for eligibility for mortgage interest relief, here again intended to promote access to credit, particularly for home ownership. And the result of all of those efforts has been a banking system that has been growing in line with the growth that we've seen with the economy, in the economy more broadly. And this is not only a recent phenomenon. If one were to look back, for example, a lot of that legislative effort that I mentioned started in the mid-1990s, like the Financial Institutions Act came in 1995. Central Bank Act, the new Central Bank Act came around the same period as well. And we saw corresponding and without a doubt consequential growth in the financial sector. So for example, if one were to look only at commercial bank deposits to get a sense of how the sector has been growing, from December 1992 to December 2014, to put that period in perspective, commercial bank deposits grew from 30.8 billion to 339.3 billion, an absolute or a nominal growth of 308.6 billion, or a 1,003% growth during that period. In fact, if I were to look more recently, and I think it is useful to compare and contrast growth during adjacent periods. If we were to look, and I think this puts in perspective what distinguishes this government from our colleagues on that side of the house in terms of facilitating and promoting economic growth. If we were to look, for example, at the growth in commercial bank deposits during the period from end 2015 to end 2019, we would see that during that period, commercial bank deposits grew by a mere 25.5% over that 4-year period. In contrast, during the period from end 2020 to June 2024, not quite 4 years, 3.5 years, commercial bank deposits grew by a staggering 67.8%, to put that in perspective. And you see the same with growth in credit to the private sector as well. During the period from 1992 to 2014, private sector credit grew from and I think these numbers are really worth placing on record. In December 1992, total credit by the banking sector to the private sector, total credit to what we describe as private sector credit, in December 1992 amounted to 8.7 billion. By December 2014, that had grew to 202 billion Guyana dollars. In other words, from 1992 to 2014, private sector credit grew by $193 billion, or 2,213%. Again, if we were to come and look at the more recent periods, during the period from end 2015 to end 2019, private sector credit grew over that 4-year period when the APNU-AFC was in government by a mere 18.2%. And in fact, contracted in a number of critical sectors, contracted in mining and quarrying by 9.5%, contracted in manufacturing by 14.2%, just to give you some examples. In striking comparison, during the period from end 2020 to June 2024, a mere 3.5 years since the People's Progressive Party resumed office, during that period from end 2020, like I said, to June 2024, that 3.5 year period, we saw total private sector credit grow by 57.8%. And underlying that 57.8% are some very important sectoral numbers that I'd like to highlight. So just for emphasis, I will repeat for emphasis, from December 2020 to June 2024, total private sector credit grew in Guyana by 57.8%. And underlying that was growth of 54.7% for real estate mortgage loans, reflecting the tremendous dynamism in the housing sector, and growth in credit to business enterprises of 74.7%, comprising 77.7% in agriculture, 44.8% in mining, 100.4% in manufacturing, and 69.6% in services. And credit to households grew by 20.4% during that period. In total, like I said, 57.8% growth in private sector credit during the period from end 2020 to June 2024. And at the same time, the quality of the portfolio, the lending portfolio held by banks, improved dramatically, reflecting the positive developments in the economy, the fact that businesses were doing better, they were making more profits, they were growing. Fewer businesses were defaulting on their loans. And so here again, just to give viewers and listeners, just to give you, sir, and our colleagues, my colleagues in the House, and those who are viewing us through the cameras so graciously provided by the media this evening, non-performing loans as a percent of total loans moved from, in December, from where it was, where the percentage was in December 2020, at 10.83%. So let me repeat that just for clarity. In December 2020, non-performing loans as a percentage of total loans amounted to 10.83%. By June 2024, non-performing loans as a percent of total loans had declined to 2.12%, reflecting a tremendous improvement in the quality of loan portfolios as a result of businesses doing better and as a result of borrowers doing better more generally in the Guyanese economy. And so, Mr. Speaker, I thought I would spend a few minutes sharing those details to make the point that there's been a sustained effort by this government over the years, in our previous term in office and since we've returned to office, to strengthen the legislative and institutional frameworks within which the financial sector operates, to improve the ease of access to credit, which is reflected by the growth in credit numbers, and to improve the quality of credit, which is reflected in the quality of portfolios held by the banks, the lending portfolios held by the banks, and the reduction in default rates. I might add, Mr. Ramjatan made a number of useful points, which I wouldn't disagree with. He spoke, of course, about the importance of capacity to implement the legislation, particularly in relation to the commercial registry. And you're absolutely, through you, Mr. Speaker, Mr. Ramjatan, we wouldn't disagree with Mr. Ramjatan in that regard. It is important that the commercial registry be equipped with adequate capacity to discharge the important new responsibilities that will devolve on it. And I will hasten to add that work, we haven't in fact been waiting on the enactment of the legislation to build that capacity. That work has in fact already started and is very much a work in progress, including the deployment of an electronic platform to serve as the registry, and training on the use of that platform, which will constitute the electronic registry in which secured interests will be entered and can be tracked and monitored. Mr. Ramjatan also made the point about litigation and overburdening the court system. It will be recalled, Mr. Speaker, that it is in fact this People's Progressive Party civic government, well in fact in our pre-2014 term of office, who worked with the judiciary to introduce rules of court that would see the introduction for the first time in this country of a commercial court. And it would be recalled that the introduction of a commercial court with the exclusive mandate of hearing commercial matters did make a tremendous impact on the speed with which commercial matters were considered and ultimately were concluded. And here again, you know, we know as much as we share, you know, with every other stakeholder group in Guyana, a recognition of the importance of efficiency in the judiciary and timeliness in the hearing and concluding of matters. In fact, it is specifically for that reason that the moves would have been made recently that would have seen a significant increase in the complement of judges who have been appointed to the judicial bench. Mr. Ramjatan also made a third observation in relation to usury and usurious lending. And I want to make the point that this legislation, in fact, this bill, responds directly to that concern, because there are a lot of people who previously might have been unable to access credit because they did not have immovable property. They only had movable assets. And many of them, or they were seeking to buy movable assets. And in the absence of immovable property, ended up having sometimes to buy assets under very loose hire purchase arrangements, sometimes going whether it's, I don't want to single out any particular sector, but they were buying a big piece of equipment, or they were buying some vehicles, or they're buying something else on some kind of credit arrangement, and ended up paying what would have been really exorbitant effective interest rates because they didn't have access to credit in the formal financial system. First of all, the Hire Purchase Act, which we brought to this Parliament, which the Honourable Minister brought to this Parliament, would have helped to address that question in the formal hire purchase sector, improve transparency in the formal hire purchase sector. But in addition, recognizing the fact that there are still some people who might not, for a variety of reasons, have access, particularly because of their unavailability, the unavailability of immovable collateral, but who would ordinarily have movable assets that they could pledge. What this security interest in movable property bill does is it now provides an avenue through which those persons can actually have access to the formal financial sector and the formal banking system by pledging their movable assets as collateral, and thereby potentially helping them to access interest rates that are available in the formal banking system that are much more affordable than the usurious interest rates that would otherwise only be available to them if they were forced to access credit outside of the formal banking system. Mr. Speaker, there is much more that I could say and would very much like to say on, you know, the remarkable transformation that is taking place in the financial sector, and that we will continue to aggressively push to see implemented in the financial sector. It would be noted that earlier today, I had the privilege of tabling on behalf of the government and a proposed amendment to the Financial Institutions Bill, which will lay the foundation for international banks to open representative offices in Guyana, which we anticipate will see big international banks now taking a first step to entering the Guyanese market, an extremely positive development, and the bill to facilitate this was tabled earlier today. And when we debate that, we will no doubt speak more about it. But like I said, the point that I wish to make, Mr. Speaker, in conclusion, is that this security interests in movable property bill is a most commendable and a most welcome addition to our legal architecture in the financial system. I commend my colleague for bringing it to Parliament on behalf of our government. I'm delighted at an opportunity to speak in support of it, and I am particularly pleased to hear Mr. Ramjatan, on behalf of the opposition, express his strong support for the bill too. And with those words, Mr. Speaker, I commend the bill to the House and will, at the appropriate time, urge its unanimous passage. Thank you very much, sir.
Thank you, Honorable Minister. Now for the Honorable Minister of Tourism, Industry and Commerce.
Thank you, Mr. Speaker. Mr. Speaker, in wrapping up this very short debate, I wish to thank my colleague, the Honorable Dr. Ashley Singh. I wish to also thank the Honorable Kemraj Ramjatan for his support and their contributions in the support of this bill. I wish to also acknowledge the contributions of the public servants who have worked extensively to prepare this bill and the other stakeholders who collaborated and whose contributions have made the bill what it is today. This bill, Mr. Speaker, in closing, will bring a sea of change in the commercial environment by addressing what has been identified by many stakeholders to be a very key need in the business environment. The creation of a comprehensive framework for secured interest in movable property will remove a key constraint that has confronted thousands of Guyanese citizens and small businesses. The bill opens up avenues of credit previously unavailable to them. When this bill becomes law, lack of immovable property will no longer be an insurmountable barrier to the dreams and aspirations of ordinary Guyanese people. And I therefore commend this bill for passage in this House. Thank you, Mr. Speaker.
Thank you, Honorable Minister. Honorable members, I put a question that the Security Interest in Movable Property Bill 2024, Bill number 20 of 2024, be read a second time. Those in favor say aye. Those against say no. Ayes have it. Let the bill be read a second time.
Security Interests in Movable Property Bill 2024, Bill number 20 of 2024.
Honorable members, we will resolve ourselves into committee to consider the clauses of the bill. Honorable members, Bill number 20 of 2024, the Security Interest in Movable Property Bill 2024, has 102 clauses, and I propose the question that clauses 1 to 102 form part of the bill. Honorable members, I now put the question that clauses 1 to 102 form part of the bill. Those in favor say aye. Those against say no. Ayes have it. Clauses 1 to 102 now stands part of the bill. Honorable members, I now put a question that Bill number 20 of 2024, the Security Interests in Movable Property Bill 2024, be reported to the Assembly. Those in favor say aye. Those against say no. Ayes have it. Let the Assembly resume. Honorable Minister of Tourism, Industry and Commerce, Honorable Onej Walron.
Report that the Security Interest in Movable Property Bill 2024, Bill number 20 of 2024, was considered in committee clause by clause and was passed without amendments. I move that the bill be now read the third time and passed as printed.
Honorable members, I now put a question that the Security Interest in Movable Property Bill 2024, Bill number 20 of 2024, be now read a third time and pass as printed. Those in favor say aye. Those against say no. Ayes have it. Let the bill be read a third time.
Security Interests in Movable Property Bill 2024, Bill number 20 of 2024.
Honorable members, we will now proceed with the second reading of the Wills Amendment Bill 2024, Bill number 17 of 2024, published on the 22nd of November of this year. Honorable Attorney General and Minister of Legal Affairs.
Mr. Speaker, it is my privilege to rise to introduce for its second reading Bill number 17 of 2024, the Wills Amendment Bill 2024. Mr. Speaker, this is a small legislative intervention, but it has great practical value and would bring reprieve and redress to a wide cross-section of our population. Mr. Speaker, death is inevitable. And one of the important documents that each of us and all of those who are listening will have to contemplate making at one point in time, or should contemplate making at one point in time in their lives, is a document called a last will and testament. Because it is that instrument that permits the maker, who is called a testator, to dictate how that testator's properties should be distributed upon death. That document called a will has been in the British legal system for over 400 years and would have devolved on all British territories after it would have gained independence. Guyana, being one of those territories, inherited the British concept of a will. And today we have a legislation that governs the making of wills, and it's called the Wills Act, Chapter 12:02, Laws of Guyana. And it came into force in the colony of British Guyana in 1906. So it's a very antiquated piece of legislation, which has not undergone much change or many changes over the last 120 years or so. And this change comes because of a necessity for the change. Mr. Speaker, as expected, a will must, before its validity is maintained, must comply, as one would expect, with certain formalities in order to protect the validity of the instrument. And the formalities are quite settled and have remained intact for the last 100 or more years. And the formalities are very simple. The will must be in writing, and it must be executed by a testator, meaning the maker of the will, who must be of sound mind and memory. So you must be corpus mentis meaning that your mental state must be intact to render you capable and mentally capable of executing a will that will govern your affairs after you die. Apart from the testator must be of sound mind and memory, the will must be in writing. Thirdly, the will must be signed by the testator or someone authorized by the testator. And if there is no signature or the testator cannot sign, by affixing some mark of the testator, by the testator, or upon his instructions, and the mark must be situated at the bottom of the will, meaning that the dispositions must be at the top, and the mark or the signature must be at the end. Anything falling below that signature will not, or mark, will not be considered part of the will. And the other most crucial, or as crucial requirement as any of the above, is that this will must be witnessed by two witnesses who must subscribe their signature or their authorized mark next to the signature of the testator. And these two witnesses must sign, they must see the testator sign, and they must sign in the presence of each other. Those are the main formal requirements of a will before it is valid in law. There is a great belief out there that the will must be lodged at a certain place before it is valid. That is not a legal requirement. You can lodge your will anywhere. The testator also can appoint somebody who he trusts, and that to be the executor of the will, and that person is expected or is bound by law upon the death of the testator to probate that will or to apply to the court for the probate of the will. That person stands in the shoes of the testator and is to give effect to the wishes of the testator as set out in the will, including, of course, paying the just debts and expenses of the testator. So it is the net estate, essentially, that has to be distributed in accordance with the instructions of the testator. When the testator dies, Mr. Speaker, there is a procedure that is followed that allows the will to go through that process that is called probate. And the procedure for that is the 1954 non-contentious probate rules of the United Kingdom, which we have received, and those rules continue to govern the process by which wills are probated. That process requires an application to be made to the High Court for that will to be probated. That application must be accompanied by a number of documents. Among the documents that are required is an affidavit from one of the two subscribing witnesses. And that affidavit, once there, with all the other statutory documents, would constitute the requirements for the probate to take place. The requirement for that witness is mandatory for the purpose of probate. However, if the witness cannot be found, then the person who is undertaking to probate the will has to follow a course of action to satisfy the court that efforts have been made to locate one of the two witnesses, and those efforts have been futile. Now, though I am standing and speaking the steps as they are required by the law, the actual process is not as simple. Because if you cannot find the witness, you simply can't go to the court and say, I can't find the witness. You then have to go with an application to the court for leave to advertise for this witness, having sworn an affidavit to say that all my diligent efforts to locate this witness have been futile. So you first have to say that to the court, and then seek the court's leave or permission to advertise in a daily newspaper circulating within Guyana for one of these witnesses to come forth. And that is why, sir, if you pick up the Chronicle newspapers today and you look in the classified ad section of that newspaper, or the Stabrook News for that matter, or the Kaicho News for that matter, you will see pages of notices of the type to which I'm making references, inviting the person whose last known address is stated as it is known, and that person is invited to make contact with the attorney at law for the person who is making the application for the probate. If that witness does not respond to that advertisement, then another application has to be made to the court, and to that application, the advertisement will have to be annexed to demonstrate to the court that in compliance with the court order, an advertisement has been placed in the newspapers inviting this particular witness to come forward, and no such person came forward. It is only in that circumstance that the court will dispense with the requirement of an attesting witness and proceed to probate the will. Now, in the ordinary course of things, people don't know, well, no one knows when they are going to die unless they are terminally ill. So, a person can make their will in the year 2020, but they die in 2025, or even a longer period between the date of the will and the date of death. And even more complicating is the fact that even when death comes, the application for the probate may not be made in a timely manner. So you have another few years that can possibly elapse without an application being made for the probate. And every time there is a distance in terms of time, you have difficulties in locating the witness or the witnesses. Because as I said, the witnesses would have subscribed to the will at the time when the will was made. So death may come 5 years after, and the probate, the application for probate, may come 5 years after death. So you're talking about a 10-year period right there to locate a witness who sometimes is not even known to the testator, because wills are normally made by lawyers, and when the lawyers take the instructions and they make the will, they ask a secretary, or they ask a clerk, or they ask someone who may be in the office to witness that will. And these are not persons who are necessarily known to the testator. So right there you see the vagaries and difficulties that are attendant in securing the signature of that witness on that attesting affidavit in order for the probate of the will to take place. It is against that backdrop, sir, that this amendment is being moved. And this amendment simply permits the witness, when he or she signs the will as a witness, to execute that attesting affidavit to say that I witnessed this will. And the testator executed this will in my presence, and he appeared to be of sound mind and memory. It is that affidavit, instead of being executed years after the making of the will, is now, the law is now permitting it to be made at the time when the will is made and at the time when the will is being witnessed. For the simple reason that at the appropriate time, one would not have to go looking and expend great amount of money and time in seeking to secure the signature of a witness. That affidavit would be executed at the time that the will is being executed and shall be stapled to the will as part of the will. Well, not as part of the will, but as an annexure to the will. So that when the deceased relatives go to a lawyer to probate the will, they are going there with the will and at least an affidavit of one of the attesting witness, saving themselves a lot of time and a lot of money and bringing great speed to the probate process. Mr. Speaker, in our country, in Guyana, estates are normally done by the Chief Justice or the judge holding the office of Chief Justice. And this document, this amendment, has been inspired in part by representations made by the current Honorable Chief Justice, who explained how many cases have to be delayed and how much resources have to be spent in dealing with applications to dispense, to advertise for witnesses, and to dispense with the need for an attesting witness. So, Mr. Speaker, and one thing that I should also emphasize is that the failure to take advantage of this facility which the bill offers does not affect the validity of the will. So if you fail to execute the affidavit at the time of the will, it doesn't affect the will. You simply will have to go through the elongated process of going to locate that witness at the time when you're making the application for the probate. So this gives you an opportunity to conveniently and at the same time execute that affidavit and save everyone a lot of problems and save the estate a lot of unnecessary expenses. Mr. Speaker, we also took the opportunity of adding to the Wills Act, a very old legislation, a power in the minister to make regulations, because we may have to come back and make changes. So we thought it best to give the minister a power to make regulations at the same time, and to create offenses if at the time that is thought to be desirable, to create offenses when there is a breach of those regulations. Because wills can be forged and a lot of things which are prosecutable and chargeable under the ordinary laws of forgery. But if we decide to promulgate regulations and there is a breach of those regulations, well, you want also a power at the same time to punish the breach of those regulations by permitting criminal offenses to be created. So, Mr. Speaker, that in short is what this amendment is about. It should not invoke any controversy whatsoever. I can't imagine any objection being made to this amendment. This amendment will help every single Guyanese who decide to make a will. And let me give some public legal advice. Every person should consider making wills so that when you die, disputes, unnecessary disputes, do not arise in relation to how your properties should be distributed. Those must be clearly set out in your will. Disputes may come, you can't stop it, but at least reasonable steps would have been taken to minimize those disputes as far as possible. And this bill helps with the expeditious process of concluding the final legal rights in terms of the estate and assets of a deceased person. I commend this bill to the House. Thank you very much, Mr. Speaker.
Thank you very much, AG. Our next speaker is Miss Annette Ferguson, the Honorable Member.
Thank you very much, Mr. Speaker. Mr. Speaker, I stand on this side of the House to give our support to this bill, Bill number 17 of 2024, the Wills Amendment Bill. First of all, Mr. Speaker, I want to assure the Attorney General and also those on the opposite side that we on this side of the House will give our full support to the bill. I also want to commend the Honorable Attorney General for his explanation, the background to the previous bill, the Principal Act that is of 12th of 1906, I think it is, and also what this amendment will seek to address to bring relief to families. And I do agree with you, Honorable Attorney General, that death is inevitable, and it is our responsibility to ensure that we leave, things or make things easy for our loved ones, that they wouldn't have to go through what the previous act or the Principal Act speaks to. So I think though, Mr. Speaker, the onus is on us as leaders to ensure that these information, the critical information is made public, because yes, at this time of night, at 10 past 10 this night, many persons are not up to hear what, the Attorney General just shared here with us. So I am calling on all of us, the government. I know you have your program issues in the news, and you have tomorrow we have a presser, the normal Thursday presser. So rather than being um, you know thinking, rather than the honorable member using his platform tomorrow to probably abuse out the opposition, I would encourage you, Honorable Attorney General, to encourage that honorable member to ensure that our masses are educated so that persons will do what is necessary. So I think, Mr. Speaker, with those few words being said, I want to say to the Honorable Attorney General, you have our full support in this simple amendment. So may God richly bless us all. Thank you.
Thank you very much, Honorable Member, Ms. Ferguson. Honorable Member, Ms. and Minister of Education, the Honorable Priya Manikchan.
Thank you very much, Mr. Speaker. Mr. Speaker, at this late hour, I will be as short as I can. This is a small and simple amendment that I think will go a far way to the people who have to use the courts for probating of wills. The Attorney General went through what the formalities of a will are, but for the completeness of my presentation, I will go through them again. It is important, I think, massively important, especially coming from a big family myself, where my grandfather had 16 children, 8 of who remained alive for a long time. So I saw that in a real way, to leave yourself in writing how you want your assets to be divided, who you want them to go to. It allows you to negate, I wouldn't say prevent, negate or lessen conflict amongst those surviving you. It allows you to leave to friends and pets and charities if you want to. A will gives you the opportunity to speak as though you hadn't died about how your assets are going to be distributed and to who. For a will to be eligible for probate, it had to have gone through certain formalities. It must be in writing. It must be signed by the testator, the person who's making it, or marked by him, or at his direction and by his I mean his or her presence, marked or signed in their presence. It could be in writing on any material. It must have an attestation clause, and it must be witnessed by at least 2 persons who are present at the time that the person is signing, the testator is signing. They must see the testator signing, although they don't need to know what it was he was signing, and they must be present at the same time and see each other sign. Those are the requirements. So a testator must leave the will in writing. He or she must mark it or sign it. And there should be 2 witnesses who say as an endorsement that I saw the testator sign and we saw each other sign also. To do all of that, the testator had to have been of sound or appear to have been of sound mental capacity, so that he or she had the mens rea and understood what it was they were doing. We have not yet, sir, and I'm very glad that we've included here the ability to make regulations. Guyana, so many years after independence, has not made our own probate rules, non-contentious probate rules. So, by our Civil Law Act, we have adopted the non-contentious probate rules of the UK of 1954, prior even to our independence. And it's those rules that we use, Mr. Speaker. What is required when a person dies and leaves a will is that the executor named in the will, that is the person who will take care of the deceased's business, or if no executor is named, there are processes by which it is determined who will do it, must go to the court and ask the court to validate the will, to say that this is the testator's intention that is left here in writing, this is the will, and this is how the properties must be, or assets must be divided and distributed, bequeathed and devised. And one of the requirements that has become standard, although it is not required, and I'll come to why I'm glad we can make regulations, Section 10 of the non-contentious probate rules that we follow do not require affidavits of attesting witnesses. A court can ask for it if there is doubt about whether this testator actually executed this will, but it's not a requirement. Over time in Guyana, courts have made that a requirement, that one of the documents that must be submitted is an affidavit of an attesting witness that says this person saw the testator sign. And I am saying to you that the non-contentious probate rules that we currently follow do not require that. So this is a good time for us to, sometimes these rules develop for reasons, and these practices, not rules, develop for reasons. So what was the purpose of having two witnesses sign as, or attest that they have seen the testator sign? It is because by the time the will comes up for probate, the testator would have died. And so he's the only person, he or she, who could say, this is my document, this is what I wanted. That person is no longer alive. So I think the logical conclusion was that these two witnesses would be alive to say, yes, we saw him sign, we saw her sign, she was of sound mental capacity, this is what this person wanted to happen with their assets. So if there was any doubt that this is the will, but it's if there was any doubt that this will was an authentic document, then a requirement would be asked for an affidavit of attesting witnesses. Guyana has developed a practice where before we file anything, they ask for the affidavit of attesting witnesses or a witness, perhaps because they want to be sure from the beginning, or perhaps because cynicism and experience has taught that many inauthentic documents have been attempted to be probated. The reality becomes, and let's take my grandfather's will. He goes 20 years before his death to then an old lawyer named Laltaram Gopal and executes his will there. The two witnesses on that will were clerks in an already aged lawyer's office. Chances are they themselves were aged. He dies 20 years later. 5 years after he dies, or 3 years, no, 4 years after he dies, his executor attempts to probate the will. So we're talking about a 24, 25-year period. And then the executor is forced to go find two scribbles, the names and persons of two persons they never met, never knew, were just clerks in an office. There are some law offices that have clerks who were there for 30 years, and there are some law offices who change clerks every 2 years. So you could well be chasing down someone who is living in New York or New Jersey. They're not even there legally, so you can't find them officially, and you definitely can't get them to go attest to any affidavit to say where they are and that they saw this will signed. So you have a problem now with providing to the court something that has become necessary, although it is not a legal requirement. And that has caused a lot of families a lot of trouble. You simply can't find these witnesses, then you got to go and spend a lot of money on making application after application to advertise for the witnesses and then advertise for, apply for the will to be probated without the witnesses. This amendment allows lawyers now and testators, because I know a lot of people don't go to lawyers. They stay home and they make their wills, or they go to JPs in the community. So I hope the JPs are going to be, and the lawyers are going to pay attention to this amendment. And right there, as they execute the will, whoever is the witness, whether it's a clerk or a neighbor, hopefully not a beneficiary, because then the gift would lapse, but the witness would be good. If they can attest right there at the bottom of that will, or on a separate document that is attached to the will, that they saw the testator sign, that he was of good mental capacity, sound mental capacity, that they saw another witness sign, that everybody signed in the presence of each other, and that document would be used 20 years, 30 years when the probate is going to happen. And so it make life a lot easier. And for that reason, I commend this amendment. But to the Attorney General, I say this is a good opportunity for us to remind ourselves why we wanted the Law Commission. These are pieces of legislation that have so much more work that can be done with them in a holistic way. I am not of the APNU AFC view that we must study everything and then before we actually make any amendments. I believe we can make amendments even as we are looking at holistic changes. But I think the section, the clause in the bill which allows the minister to make regulations really opens the door for us to make our own non-contentious probate rules here in Guyana that are Guyanese, that are unique to us, and that take our realities into consideration. And I think this is a good opportunity, too, for us to remind ourselves that we have a law commission, and that is where these are the kinds of holistic study I'd like to see happening. This is an entire area of law that is used every single day in the courts, and that can cause people, entire families, a lot of pain, including with a lot of division and separation between siblings and grandchildren and so on. And so I think this is a good area for us to look at holistically, either by regulations that the minister is now required to make, or that the minister is now entitled to make, or through our law commission that we have established. For that reason, sir, I commend Bill number 17 of 2024, the Wills Amendment Bill of 2024, to the National Assembly for passage.
Honorable Minister of Education, the Honorable Priya Manikchan, Honorable Attorney General.
Thank you, Mr. Speaker. I want to thank the two members of the House who spoke in support of the bill, and there is really nothing for me to add to what have already been said. So, Mr. Speaker, I again commend the bill, and I ask that, well, I conclude the second reading, sir.
Thank you very much, Attorney General, Minister of Legal Affairs, honorable members. I now put a question that the Wills Amendment Bill 2024, Bill number 17 of 2024, be read a second time. Those in favor say aye. Those against say no. Ayes have it. Let the bill be read a second time.
Wills Amendment Bill 2024, Bill number 17 of 2024.
Honorable members, we will now resolve ourselves into committee to consider the clauses of the bill. Honorable members, the bill has 3 clauses, and I propose the question that clauses 1 to 3 stand part of the bill. Honorable members, I now put a question that clauses 1 to 3 stand part of the bill. Those in favor say aye. Those against say no. Ayes have it. Clauses 1 to 3 now stands part of the bill. Honorable members, I now put the question that the Wills Amendment Bill 2024, Bill number 17 of 2024, be reported to committee. Those in favor say aye. Those against say no. Ayes have it. Let the assembly resume. Honorable Attorney General and Minister of Legal Affairs and Landla LSC.
Mr. Speaker, I rise to report that the Wills Amendment Bill 2024, Bill number 17 of 2024, was considered in committee clause by clause and was passed without amendments. I move that the bill be now read a third time and passed as printed.
Honorable members, I now put a question that will Amendment Bill 2024, Bill number 17 of 2024, be read a third time and passed as printed. Those in favor say aye. Those against say no. Ayes have it. Let the bill be read a third time.
Wills Amendment Bill 2024, Bill number 17 of 2024.
Honorable members, by agreement of the Chief Whips, this will conclude our business for this 90th sitting of the National Assembly. I want to take this opportunity to say we have had a very busy year, and as we close on an extremely busy year for the National Assembly and a momentous one, I take this opportunity to extend to you and your families season greetings on behalf of my family and I, to the staff, to the clerk and his staff and their families. May they have a joyous holiday season. To the staff of the convention center, the security forces, those who provide for our safe environment here and also for the sustenance. To all of them, the media, enjoy a Merry Christmas. Honorable Chris Jones, Honorable Member Ms. Valder Lawrence.
Thank you, Mr. Speaker. Mr. Speaker, it gives me great pleasure to rise on behalf of the Leader of the Opposition and members of the opposition of the APNU plus AFC to extend Christmas greetings to yourself and staff of the National Assembly and also to the staff of the Otachong Convention Center and the extended service providers to us in this house. As we depart this house, sir, I want to ask each and every one of us to take this opportunity to impact a family or two by making their lives happier at this Christmas time. This is a season of giving and love. And despite everything that Honorable Kwame McCoy has said to me, I want to especially wish him a Merry Christmas and a prosperous New Year. Thank you, sir.
Thank you very, very much, Honorable Member. Honorable Prime Minister.
Mr. Speaker, may I take this opportunity, notwithstanding my shortness of breath, to wish you and your family, Mr. Clark and his family, all members of parliamentary staff and their families, members of the opposition and your families, and my fellow members on this side of the house and their families, Merry Christmas and a prosperous New Year. Look forward to working with all of you next year.
Thank you, Honorable Prime Minister. I now call on the Prime Minister to move the adjournment.
Mr. Speaker, I ask that we adjourn to a date and time to be decided on in the new year.
Thank you very much, Honorable Prime Minister. Honorable members, we stand adjourned to a date to be fixed. Drive safe, stay safe during this festive season.
We are a peaceful people. Struggle is with struggle, and we don't look for trouble. Just ask around. But when outside faces from foreign places talk about taking over, we ain't backing down. We ain't giving up no mountains. We ain't giving up no tree. We ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one karage, not a blade of grass. This land is all I know. We gonna make it somehow. We will bend like a bow and never break. Our fathers came here and they lived and died.